Hi students, I welcome you all to the Company Law Marathon. In this marathon, I will be giving you extremely important things with which you can get not only clear your company law exams but get an exemption as well. Okay, so just before I start, let me give you a small introduction about myself. So I am Professor Zubair Jahangir. I'm a company secretary and an advocate. I have been teaching the CS course for over 12 years now, and I've also taught at the ICSI as well. Now, in this marathon, let me tell you what I will be doing. So, first, the detailed lectures I have already provided it to you at a nominal price in the Dream Batch. Okay, so you can go ahead and enroll into the Dream Batch. The links will be given in the description of the video. With the Dream Batch, you will get access to all the paid lectures at less than a price of a pizza. So go ahead and enroll it. Okay. Second, in this marathon, I will be giving you extremely important things, even if you've studied your company law before, but the things that you miss out will be covered in this marathon. And after this, you will be a master in company law. Now, just before that, let me tell you that last attempt also, our student got the highest marks in company law, and you will not see anyone who gets a higher marks than these. Okay, so she got 74 marks in company law. Okay, so it's a very big high number, and this is probably the highest in India as well. Okay, so the reason why I tell you is not to for any other purpose, but except to motivate you that even you can get these marks as well. Okay, so 74 marks in a theoretical paper which is extremely difficult as well as difficult to crack it. So these are the same principles. She was a student, so she has access to our lectures and the exemption marathon as well, which is today. So that should be the first motive. And now let's begin. Okay, so good to go. Can you tell in the chat box whether I'm audible and visible, and we will quickly start with the marathon. Okay, so that should be the target, that you will get an exemption. Write exemption in the chat box, so you will be sure that you will get an exemption. Okay. Yes, the marathon will be useful even for CMA law students as well. You can see what all contents are, correlated. You can definitely study them as well. Okay, so let's begin. Okay. And just remember that these lectures will be in English, so that if you mainly are students from the southern region, they don't understand Hindi that well and they don't have that many options. So we have taken our lectures. This entire lecture will be 100% in English as well. So if you are from the south, please share it and communicate to your friends as well, so even they can help and make the most out of it from these lectures. Now, these notes which I have prepared for the marathon are extremely useful. I will take you through and then I will ask you, should I share it with you all or no, or you all can make a notes while teaching it. Okay, so first let me know in the comment section if you need the notes, so after the marathon is over I will share it in our WhatsApp groups as well. Okay, so or whether you can copy the content while I'm teaching, so that's also fine. Sure, let's begin. Hi, so we'll be starting with the company law exemption marathon. What is the company law exemption marathon? This is a master guide to get extremely good marks in your company law subject. Okay, so the very first thing is your exemption. What is an exemption? A exemption is 60 plus marks in company law. So after you follow these principles that I tell you and this particular sheet, which I will share it in the WhatsApp group, and also I will put it out on the website after the marathon is over. Now, first let's see what is the basic principles to crack this exam. So the very first thing is, what students miss out is what you have to understand. First, if you go to see, many students don't know the sections only. If you don't know the section, it's extremely difficult to score an exemption. After the marathon, I guarantee you, you will be a master of all the sections applicable to your particular exam. This is a guarantee. First, what questions come in the exam are drafting questions as well. They ask you to draft certain kinds of notice. They can ask you to draft certain minutes, and they ask to draft certain resolutions. Approximately 15 marks of your paper could be drafting. So this is what students normally, while studying the entire company law, don't even see, don't even study, and might not even know. I have going to cover this entire drafting of 15 marks for you in this marathon. Second thing what students miss and don't know is how to frame a situational question. I have learned from my experience by teaching so many students over the years is that good level of knowledge doesn't mean good marks, and less level of knowledge doesn't mean less marks. What matters is if you can present it to the examiner that you have high knowledge. That's all that is required. So if my paper is well structured and to the reader it appears that he is extremely knowledgeable, you will get the marks. Second, while writing the answers, students don't know how much content to write. Whether should I write small content, should I write big content, should I write related, unrelated, what should I write? So let me tell you, first how you plan it is a 5-mark question has to get over in 7 minutes. So this should be your target time, that a 5-mark question should be 7 minutes, and ideally it should run into 1.5 side. 1.5 side, unless it is a direct question and it ends really, they tell you write 7 points and 7 points are over, but that mostly doesn't happen. So 1.5 side is what I expect you to get, because if you can, out of 5 marks, if you can score 3 marks or 4 marks, you will be in the toppers category. Okay, so you don't have to write too much content also where you waste time. You have to understand that when I write the answer, I should be able to pull out 3 to 4 marks, and that's it. You have to stop the writing the content there. Next is where students lose the marks are the sums. In company law, there are sums. These sums are related to the legal provisions. Those also in this marathon sheet I have covered, because this is all the things that you lose, and without this it is impossible to get a marathon, to get a exemption. Clear till here? And then I will take you through chapter wise important questions as well. I don't know whether I should do that, where I should give you all the importance that will hit in your examination, and that is exactly that would be coming in your examination. So should I do that, or I should teach you all everything right now? Exam related important questions in a 1 day time, what we can cover is the important exam topics. So this marathon is going to be about that. The detailed topics, all you need to do for your knowledge, etc., it's given in the dream batch. So let's begin. Okay, so these 3 things is all you should know. The first thing that I will be covering is the drafting part. Okay, so from here we start. First is drafting, legal drafting. They ask you, imagine if you don't know how to draft, or you don't know the basic structure, out of 5 you will get a 0. And if you know it well, it's very easy to score 3 and 4 and get very good marks. And the best part is, if I tell you to write, now what is drafting? If I tell you write a letter to your friend telling him how much you enjoyed in Diwali, and if I tell you that write a letter to your friend how much you enjoyed in Christmas, don't you think that the format will be the same? Internal content can be written, but if you don't know the format, you get a 0. So this particular thing is going to teach you the formats which are applicable in all cases. Okay, so let's see which is the first one and what comes in your examination as well. And these are all exam questions. It's not hypothetical that I'm telling you that they can come. They have been asked and they're very important, and students normally miss out to study the drafting questions, which are extremely simple. In the next 10-15 minutes, this thing will be done for you. all the drafting possible questions. Okay, so let's see what is the drafting. What do I mean? First, when I have to call a meeting, when I have to convene a meeting, what do I have to give to all the shareholders and the directors? Do I send them a WhatsApp message, please come on this day, we'll talk about these things, and he puts a thumbs up? You think that's a formal way? No. You send a what? Notice of the meeting. Even in your buildings, a notice is put for EGM, etc. That we will see, it has to be in a specific format. In the note, in the meeting, what do? Do they fight or they pass resolutions, or both? Both. Okay, so the second thing is resolution. What is a resolution? Is when the company decides on certain aspects, which was certain proposals, when they have got the requisite majority, they become a resolution. So how to draft a resolution also we'll see. And the last, there might be multiple resolutions. All of them in the end will be contained in the minutes book. What is a minutes? A minutes is a recording of the meeting. Who, when it started, when it ended, who all had attended, who was the chairman, which all resolutions was passed, and who was the company secretary, etc. Okay. Now, normally, can I say that the format will be slightly different if I give you notice of board meeting and notice of general meeting? Formats will be different, yes or no? Somewhat different. I'll tell you what is the difference. Normally, in notice is nothing but an intimation. I'm informing you that please come for the meeting. So all of this will be in the letterhead of the company, yes or no? All notices will be on letterhead of the company. So when you see a letterhead, what all do you see? I see the name of the the company, the registered office, the SIN number, corporate identification number, email ID, and website. This is a format for the letterhead. Below that, then you will write the notice of the 21st board meeting, 3rd board meeting, 4th board meeting, etc. Notice of the first board meeting. Okay, so then you will write the date 2. Now notice is individually sent to each director. So we will write date to Mr. XYZ, director of the company, dear sir or madam, and that's it. The simple line is, it is even there in your building, same format will be used. Notice is hereby given that the meeting for XYZ is held on so and so date at so and so place at so and so time. You are requested to attend, and the following is the agenda. So the format is, notice is hereby given that the board meeting, the 21st board meeting of the ABC Limited will be held on so and so date at so and so time and at so and so place to transact the following business. Now, in the notice of the meeting, you will always see something called as agenda. Why do you think the board of directors are meeting? To do what? What would they do? They would discuss certain proposals, matters. Those are called as the agenda. So then you will say to consider and approve appointment of additional director, to discuss to give interim dividend, to take a note of change of registered office, any kind of qualification of the from the auditor. So anything can be done. Agenda is there. Once the agenda is given, so now what we did see, letterhead to the director, notice is hereby given that the meeting will be held. This is the agenda. Then what? How do I close it? That is also equally important. How do I close this letter? So first we'll tell that you are requested to make it convenient to attend this meeting. You are requested to attend the meeting. You can participate. Directors can participate in person and video conferencing. Isn't it allowed in company law to that board of directors can attend through video conferencing? Under which section? 173 subsection 3. They can attend. Okay. Through this also. Kindly confirm your participation. So you'll see 173 all talks about your attending of board meeting allowed in rule read with rule 3, that you can even attend it through video conferencing. Then you will end it for the company, and then you will put your sign as a company secretary or the authorized officer, place and date. Concept clear till here? Now, if they tell you draft a notice of the board meeting, format will be the same, just whatever contents they tell you, for whatever you will add it here. Clear till here? It's basically fill in the blanks after that. Now let's look at, I told you there will be slight difference in notice of board meeting and notice of general meeting. Can anyone tell me what difference will be there in general meeting? Or I will tell you, let's look at the format. You tell me what difference can you see? Specific notice of general meeting. Okay, this is a notice of general meeting in shareholders meeting. Letterhead is the same. Yes. Now that heading will be the same. Notice of whatever dash meeting, board meeting. Here it is general meeting. That is also same. Notice is hereby given that the AGM of the company will be held on so and so date at so and so time to discuss the following matters. Still here also same. Everything is the same. But only difference is the agenda is split into two businesses. Ordinary business and special business. Concept clear? So agenda is just broken down into two kinds of businesses. One is ordinary business. Only 4 kinds of businesses today are treated as ordinary business. It's called as adda. Only these 4 are ordinary business. Lest all the matters are treated as special business. If it is a special business, you have to add a explanatory statement. Say, if it is ordinary business, explanation need not be given. Explanation is not required. Concept clear? So if you will see in special business, if I give you item number, then they will also give you the explanatory statement. Concept clear? Very important. In special business, explanatory statement is compulsory. If you've not done, you've done a mistake. Okay. So let's see what is ordinary business. Ordinary business is something which is obvious that when you're coming to a meeting, dividend related discussion will be done, whether dividend should be given or no. Accounts of the company will be placed, common sense. Do you need explanation for that? No, it's understood. Anyone coming in the meeting will know dividend, accounts, auditors related topics will be discussed, and which is the last one? Dividend, directors, auditors and accounts. For this, no explanatory statement is given. No explanation is given. It is self-explanatory. It is understood for anyone. But special business is anything other than that. For example, if I am going to tell you that I am going to shift the registered office. If I tell you that I am going to shift the registered office, wouldn't you want explanation why? If I tell you I am going to change the objects of the company, don't you want explanation why? If I tell you I am going to change the name of the company, don't you want explanation why? But if I am proposing a dividend, you don't need explanation, it's understood. It's not something different that's coming up. Okay. So you will write and then you will write the resolution. We'll see how to write resolutions now. And then you will say the board recommends passing of the resolutions. So when the board is there, they will tell that we recommend that these things should be passed subject to your approval. We are recommending, and then when all the shareholders give their voting, then it will be passed. Then you will write the line by order of the board, company secretary, place and date. Concept clear? And then if you go to see, this was never there in your board meeting. Another extra thing that you're seeing is this new. If you remember, members can send a proxy. Proxy form has to be given how many hours before the meeting? 48 hours. So proxy form, proxy need not be a member. A member who is there can also appoint a proxy, which is not needed in board meeting. In board meeting, you can't send proxies. In shareholders meeting, you can send a proxy. With this, we have completed the notice of board meeting and notice of general meeting. In general meeting, ordinary, special business and explanatory statement, and these notes for proxy is the only extra thing. Concept clear till here? Yes. If it's clear, can we have a smile on your face? Yes. Okay. Let's see the next format and let's see whether that smile is intact or no. Okay. The second format is for passing resolution. It is the most commonly asked format, and for your exam also it will be asked. Okay. Last time also I had told the students that these will come, and those only have come. Okay, so now only you will be able to say in future that sir told and it came. Right now, past you will only doubt. Okay, but and by the way, you can even see the lectures on YouTube, which is there for drafting in company law. I've taken it, or even in a dream batch. There I told it will come, and you see the December 2025 paper. All the formats same have come. Okay, so because it's the same format, companies just do this only. They're nothing different. Let's see. Now passing of resolution. Now what is a resolution? A proposal was passed that we want to shift the registered office. In the meeting, everybody came and agreed to shift the registered office. So company passed a resolution that we have resolved to shift the registered office. As a company secretary, you are asked to make the resolution. 5 marks. You all can start writing. You all know how to write? No. So now you will know. Now first thing is how to start writing. First you pick up your pen and then you write the title of the resolution. Sir, what is the title? Title is exactly what are you asked to do. If I tell you pass a resolution for alteration of MOA, you will write resolution for dash. If I tell you a resolution should be passed to change the name of the company, so you will say resolve that resolution for change in name. You have to put that. Okay, if I tell you resolution for appointment of director, you will write resolution for appointment of director. So this is called as the title. Concept clear? Then you will write type of resolution and type of meeting. Okay, type of resolution will be whether it is an ordinary resolution or a special resolution or a board resolution. Okay, so you will say whether it is a board resolution or it is a, in general meeting, which resolutions we have? Ordinary resolution or a special resolution. Okay, so that you will write. Then you'll write in which meeting it was there, type of meeting. Type of meeting. Concept clear? Whether it is in a board meeting or in a general meeting. I want you to write it down with me. Okay. Now we'll start the resolution. Can you see the resolution is only this much? And out of 5, 3 marks is guaranteed for giving this. You don't have to make it big. It is exactly how you have to write it down. Nothing more, nothing less. After the title, so I'll just give you the format also in case if you want to write it down. First, what did I tell you? There will be the title. Then in the title, I will write below that, I will write type of meeting, and then I will write type of resolution, and then I start writing. When I start, how do I start a resolution? Writing a resolution. Once upon a time, there was no. You will write in all caps, resolved that. Okay, resolve that, and now let's see what is the format. And then you always start with the line resolve that, resolve further that, and all caps. Let's see. Now, resolve that pursuant to section dash read with rule dash of the company has be and hereby accorded for. Copy the title. That's it. This much line you have to write. Let's see. I'll repeat it again. Resolve that pursuant to section so and so, read with rule so and such other approvals as may be required. For example, if I tell you it is a alteration of name. So if you're altering the name, then you have to take central government approval. So that law you have to know. That time you write in central government approval and such other approvals. So that you need to keep in mind. Okay. Resolve that pursuant to section so and so, read with rule so and such other approvals as may be required. The company, this is the line you will start with. The company be and hereby. It's just a way of saying be and hereby accords to. Copy the title. Shift the registered office. Change the name. Start a new process, take a loan, copy it. Whatever title is there, you will copy it. So your first part is over. Now you tell me, most of the students, when they go, they think they are sounding smart when they write resolve that pursuant to the relevant provision of the company law and the relevant rule of the company law. You think this language shows that you have knowledge? You think that a character is, that he is not able to understand, that you don't have the knowledge and that is why you are writing? You think that is the ability to get a exemption? No. So most of the time they say don't write section. If you write section, you will get less. But nowadays it's a competitive world. If you're planning to get an exemption, you have to know the section. Sir, how will we know the section? So how will you know the section is you will watch this marathon till the very end without skipping it. Okay. I guarantee you, you will know all the sections required. Okay. And the form numbers as well. So again, coming back, how do you write the first line? Resolve that pursuant to section so and so, read with rule so and so, the company be and hereby accords to title. Then you write the next thing is resolved further that. Now, once they have decided, don't you think they have to appoint someone to go and execute it? Just because you've decided doesn't mean that the thing will come into action. So then they will say resolved further that Mr. ABC, the company secretary of the company, is hereby appointed to do all such acts, deeds and things necessary to give effect to the aforesaid resolution. You want, you can take the video back and write it down what I have told you. Resolve that Mr. this company secretary is hereby, be and hereby, instead of saying is appointed, be and hereby is appointed to do all such acts, deeds and things as may be necessary to give effect to this resolution. Concept clear, yes or no? That is it. Take a screenshot, write it. It's a 5-mark bonus marks for you. Any resolution comes, you will be able to write. So can I say that your smile is intact? Okay, good. Now let's see the next one. So we finished, first is the notice of the meeting. Then we finished what? Resolution, right? Notice of meeting we did. Then we saw your, what is the other thing that we did? Resolutions. Resolved further. Now we will do the minutes. Now minutes, what happens is, remember we had done minutes, that in minutes the company secretary prepares the minutes. A proper minute book is prepared. It is spirally, spiral binded. It is done chronologically, entered and maintained properly. In the minutes, the company secretary will say give a summary of the meeting. Because you imagine, how will I come to know what exactly happened? If someone wants to read, I couldn't attend the meeting. Or for example, anyone who has attended the meeting wants to see that what all has been recorded in writing, because the minutes book is a evidence in law. Tomorrow any shareholder on basis of what is being written in the minutes can file a case. He can say that in the minutes book they had told that they will invest in XYZ company, why they have not done. So it's very important, and minutes preparation is also equally important. So let's see, I'm giving you the format for minutes. Very simple. Minutes of general meeting or board meeting of XYZ company. Now, will it be recorded in will be held, like notices will be held on so and so date, or it will be in past tense? It will obviously be in past tense. So the meeting of the board of directors was held on so and so date at so and so place at so and so time. Then we will tell who all was present. From here, what do you see? Who is the most important person who was present? Company secretary. Then once company secretary is there, then we will see the other less important people as well. Chairman, directors, MD, etc. Okay. The requisite quorum is present and the chairman call the meeting to order. Now again, this line is equally important, because if not mentioning that, you have made an incomplete minutes. Why? If I don't mention that the quorum was present, meeting is invalid. So writing this, that the requisite quorum was present, Okay, and the chairman has declared the same, and the meeting was then proceeded. Now this was about those who were present. What about those who were absent? So will we remember them? Those who are not there with us? So the answer is we will remember, and we will note down that they were not there. They are taking salary and not there. So we will say the leave of absence was granted to Mr. XYZ due to inability to attend the meeting. So their details are also there who did not attend. Then the minutes of the previous board meeting. Now always, if you remember that minutes of this meeting, let's say we finish the meeting, everybody goes home, then the company secretary gets around 30 days time to prepare the minutes book. Once he prepares, then it is signed in the next meeting. So the minutes, so now when we are sitting in this meeting, the previous minutes book will come to for signing. So the minutes of the previous board meeting was placed before the company and confirmed. Okay. Now we are talking of one by one item which was approved. Clear till here? Now we are going into the resolution recording. So what we did it till now, in minutes we told when was the meeting held, who was there, who was not there, quorum was present, and now we start with the recording of what all happened. Now we will say that one thing, that the chairman informed the board that the proposal for this was passed. It was discussed in detail, and after discussion the resolution was passed unanimously. Means if they tell you that with respect to investment in company ABC, so the chairman informed the board that the investment in company ABC was placed, it was discussed in detail and approved unanimously. So we will say that everybody consented to it, that is why the resolution is passed, and then you write the resolution. Resolve that, a short summary of the resolution will be given. Resolve that pursuant to section so and so, this was passed. Similarly, other matters will also be equally written, that item number so and so of the agenda. You saw an agenda, they had given you 5 items will be discussed. So item number 2 resolution was passed. Item number 3 resolution was unanimously formed. Concept clear? Any other business? So we will write no other business was transacted and the meeting was concluded by vote of thanks. So again, how do we end it? That there was no other business transacted and the meeting was concluded or ended by a vote of thanks. So everybody said thanks for coming. Let's see you next time. And this time of commencement and time of conclusion will be given. Again, very important. It is there in all the minutes. It's an essential part. And then you end it. Chairman sign, date place. Concept clear? We just take a quick recap of the minutes of board meeting. Okay. Minutes of board meeting. What is there? You tell that when the board meeting was done, who was present, who was absent, quorum was present, then each item number was discussed and approved, and no other matter was discussed, and it was concluded with a vote of thanks, time of commencement and time of conclusion. Clear till here? And we are done, and then the signature of the chairman will come. Have you all understood? Minutes of board meeting. Now minutes of general meeting, don't you think it will be almost the same? Minutes of general meeting will also be the same, Unina. First, it will also be in past tense, that it was held on so and so date. Who was present? Now, do we care of which shareholder had not come? No. So we don't write that who was absent. We'll just write for chairman was there. And then we start writing the item number so and so. It was approved after discussion. It was passed by ordinary resolution. After discussion, the particular transaction number, that is item number so and so, was discussed and approved by special resolution, by unanimously approved. And then the same line, no other business was conducted. It concluded with the vote of thanks. Very important that with respect to the quorum always has to be written that the quorum was present. Concept clear? And chairman, date and place. Is the concept clear till here? Yes. Now, just one last, they have not asked this till now, but I feel that this you should know just in case if they ask you. you should be able to know. This is basically formal letter writing. What it is? Formal letter writing you should know by default. So sometimes they can tell you that as a as a company secretary, write a letter to the board telling them the steps to make the company listed on Bombay Stock Exchange. So we are telling that as a company secretary, write a letter to the board. Now letter writing we should know now. So very simple. You write date to the board of directors of XYZ company, subject. Okay, so then in the subject you'll write what is the title, whatever they tell you, that a procedure to get listed on recognized stock exchange. Dear sir, madam. So subject you write and below that you write dear sir, madam. That this is to submit for your consideration the legal requirements and the procedural steps relating to so and so. The compliance is as follows. And thanking you. Your approval is requested to proceed further in this matter. Thank you. Signature of the company secretary. Concept clear? With this, we have completed all the formats required under company law. So very simple. This I will tell you, we have completed 15 scoring marks. It's either all in, either you get all or nothing. If you don't know the format, it's almost a zero. So it's impossible to get an exemption. Here, knowing the format is very good because any particular question comes with respect to drafting, you have to get a 3 as long as you put all this. And whatever question be, the format will be the same. Only the facts have to be changed. Clear till here. So we are done with the first part of the marathon, which I told you that this is what students leave, which because of which they cannot get a exemption. Drafting. Now you know how to draft notice, how to draft minutes, and how to draft resolutions. So very good. Very nicely taught also. Okay. Next we go to situational questions. Now situational questions, students don't know, they expect that what they are studying in the module or in their notes, exactly like that questions will come in the exams. They'll get a shock of their life if they've not looked at the past exam questions. And if they have also looked at the past exam questions, they will get a shock of their life if they have not prepared for the writing the situational answers and they look at their own marks. This is one of the biggest that draws down your marks, not knowing how to present your answer, because your full paper will be situational questions. Ajay, company secretary of so and so, has told, give your opinion. So like those kind of questions will be there filled in your thing. Now imagine if you know this format, every single answer you will score. Vice versa, if you don't know every single answer, you will be brought down. So I'm going to teach you that format as well. So after this, you will be able to score 1-2 marks extra in every answer, because of which you will be getting a exemption as well. And in the end is the sums. Let's start with the situational questions, how to attempt. Now it's very simple, but simple things is what students don't know. Now pay attention to this. This is basically how to present, okay, how to present answers in exams. Okay, so I used to correct papers not for ICSI but for certain colleges where I used to teach. Okay, and my friend used to correct papers of ICSI students. We can't, because we are teaching, so we are not allowed by ICSI guidelines to correct papers because we are in the teaching profession. Okay, so I'll tell you what is there. What is the main thing that students have to know? In your exams, I see, now this is very, weird, but I'll just explain. If this is your paper, okay, this is your sheet, I see students randomly writing all these things without any structure. So no person has the time to locate the answer. They'll give you 2 and they'll move ahead. So this is not the correct way to present. Second biggest mistake what students do, if it is question number 1, then the points they will write 1, then sub points also 1, 2, 3, then again point 2 will be there, then again sub points 1, 2, 3. basic numbering they don't know. Right? So you have to know that this question number you will write outside, and then question A, that's it, no other thing should come here then. So for the examiner, they should know na, that question number A, then B, and sub points you will write here. If you're writing, then you write point 1, point 2, point 3. That's how you present. This is the first structuring mistake that students do. Okay, this is one presentational error. Second is the one more important thing is your knowledge. According to me, knowledge is not reflected in the marks most of the time. I might have tremendous amount of knowledge, but if I don't know how to present, and my handwriting is bad, and I don't even underline, I might not get that much marks. But let's say if someone has a little lesser knowledge but writes beautifully, presents beautifully, puts the numbering correctly, and structures the answer really well, they would end up getting more marks. Moment you've written 1.5, 2 sides, you can wrap up the answer because you will get 3 there. But some people write such short answers. This is another problem I have seen with students, okay, who are generally not law students. So since I was a law student, I already knew how to write answers because we had to fill in papers. In our law exam, we had answers where we had to write for 12 marker answers. So we had a habit of writing 7-8 sides in less time, 10 minutes. Okay, so law students generally have, but other than that, they don't have an idea. They will write 5 marks, means question number 1. I'll write 1 point, 2 point, 3 point, 4 point, and 5 point, and I will expect 5 marks, 5 out of 5. Then they get a shock. Don't do that. Your answer should be of sufficient length with sufficient quantity and quality, both. I'll tell you how you have to do it. Now, this is it. Now the structure of your situational answers. Pay attention. First, now how do I build an answer which is supposed to be small? Right? With the answer itself is small, how do I build it into 2 sides? So this is the format. First, you will write facts of the case. From the question itself, you are writing the facts of the case. Let it be of some 4-5 lines. So you have built up some answer. You get an idea while writing also, the main highlights. Then you will write the issue involved. What is the issue involved? What is the question that they have asked you? You have to frame the question. Till now I have not started writing the answer, but my half a side is already over. Then I will write the provision of law. Provision of law is you should know the section. Now imagine if I don't know the section, I lose marks in my drafting. I lose marks in my situational question which is filled up with the exam. In company law, not knowing section is as good as not getting an exemption. Okay, and sometimes not even clearing. Then you write the section in explanation, then you write application of the law to the given case. So you write that in the given case, director is whatever, and then frame it in 2-3 sentences, and you can close it with a conclusion. All these headings I need. For a corrector, you make the life of the corrector really simple. You tell the examiner this is the section, I know, okay, fine, he's given section, directly I'll get good marks. I come to know I read the conclusion. If his conclusion is right, I'll directly put a 3 or 4 and move ahead. Out of 5 marks, which is as good as 60%. Right? So this is exactly how you have to do. I am very rarely I see students, in spite of knowing that how tough company law paper and correction is, they don't do. Okay. So as I told you that our student had got 74 marks in company law. So there is a reason, right? So we just seen. So in December 2025, 74 marks in company law. So, so she had told that, she had followed all the guidelines that I had given her. You have to get it. Like, there's no reason for drawing down your marks. So it is a structure plus your knowledge. That gives you really good marks. Okay, so the reason that I show you is to know that even you can get it and you will get it. Okay. Now, first, we understand the next part of the marathon is taking each chapter. Now remember one thing, that sections I need to know, because these sections will come not only in the answers but it will also come in the drafting part. Okay, and it creates a very good impression on the examiner also. So writing it means getting good marks in company law. Now let's see, I have broken down into, now I don't know whether I should be giving you this sheet or no, because it will contain all the importance, because I know exactly what comes from past 12 years I've been doing it. So but still, sometimes students, for the students benefit, I will be sharing this sheet with you all in our WhatsApp and Telegram groups. Chapter wise I have reduced, I've put down the important questions, and you will see majority of the exam questions will come from here only. Okay, so let's begin. Now I'll take it chapter wise and I will be telling. Obviously detailed lecture you will get it in our dream batch here, or our in our full course you can go and take, you will get the full detailed lectures. Here my job is to give you a brush up with the keywords, key sections and key case laws. Then you can build your own answers. Let's begin with your chapter number 1. Now if I go to the module, I'll just open the ICSI module. Now understand, this is one part of the marathon that I will be taking. My part A importance I will be giving you. Part B, this is your directors and meetings, maybe next time, or from the dream batch you can study the meetings and directors part, because here the part A, which is around 60 marks, I will be covering each chapter wise. Meeting directors, ideally you should be knowing everything, or maybe in a second part of the marathon I'll try to cover those. Okay, great. Now in your company law part, lesson number 1, let me tell you, these are the important questions which can come in your examination. Okay, so first is the doctrines. Out of these doctrines, one of them is expected to come. One is the doctrine of ultra wires, the other one is doctrine of indoor management, third is alter ego, and the other one is your lifting of the corporate wheels, and with respect to e-governance, something about your MCA 21. Okay, let's see. So here I will just take it up, the doctrines. Now the doctrines I will just go through a bird's eye view, but you will get a proper crisp idea of what is these doctrines about. Okay, and you can complete it with me and the important case laws as well. So let's see how many doctrines are there. Doctrine of ultra wires, constructive notice, indoor management and alter ego. Okay, so this doctrines you can see it is there in your lesson 1 and your MOA. I've just clubbed all the doctrines in one, so you can study it from there. Okay, first, doctrine of ultra wires. Can you tell me what is the meaning of the term ultra wires? Ultra wires means going, ultra means beyond, and wires means powers. So company, they are going beyond the powers stated in the MOA object clause. So when the company, if company cannot do any act which is ultra wires of object clause of MOA. Till here it is clear. If I have to start off, I will say that what is the meaning of ultra wires, that normally the MOA, AOA are public documents. You tell the world that these are my objects. A company or share investor will invest reading the objects. So the company will be restricted to act within the object clause only. An object clause is given under your section 4 subsection 1 subclause C. Clear till here? Now in this doctrine you also have to write, so the ultra vires is clear that the company cannot go or do any act which is beyond the object clause of the MOA. Now the case law given is your Ashbury Railway Carriage Company versus Ritchie. So this case law you need to know mandatorily. Okay. So Ashbury Railway Carriage Company versus Ritchie. Now what happened is Ritchie was a firm of contractors. He agreed. Now Ashbury Railway Carriage Company, in their object clause, they had that they could make, sell or lend railway wagons. Railway wagons are those bogies of the railways. So they could manufacture that. However, they entered into a contract with Ritchie to finance a railway line across Belgium. So what happened? They entered into a contract with Ritchie that we will finance, we'll give you funding for making a railway line across Belgium. That is not given in object clause. So that issue involved is whether the company can do that act or no. So the decision was that since it was beyond the object clause, the company cannot act beyond the object clause. Clear till here? So what is the effect of Ultra Vires Act? Imagine if a company has done an act which is beyond its powers. So what happens to it? Is it valid or invalid? It is obviously Ultra Vires Act is void ab initio, means even if the company, all the members consent, it will still be invalid. Second, if the company has doing an act, any of the members or shareholders can go and get an injunction, stop the company from doing that act also. And if the company cannot do, but still the directors are forcing it, then who will be held responsible? Personal liability of the directors will be there. So there was a case connecting with my surname also, Jahangir Modi versus Shamji. Okay. So in this, the shareholders, it was held that the shareholders can file a case against the directors to compel them to restore the funds that they have deployed beyond the company. So doing an Ultra Vires Act, if they have done, then the shareholders can file a case on the directors that you did an Ultra Vires Act, you restore it. That can also be done. Okay. Next, can all the shareholders ratify an Ultra Vires Act? So shareholders, if they approve an Ultra Vires Act, still it will be void ab initio. Okay, they cannot do. So similarly, you can see these points close. Now, exception to the doctrine of Ultra Vires. Okay. Now understand this, that exception where this Ultra Vires rule will not apply. Now imagine if someone has done something. Now you tell me which is a bigger document, MOA, Memorandum of Association, or Articles of Association? Which is a more superior document? MOA contains the objects and they are more superior. So here this doctrine is saying that you should not do anything beyond the MOA. But if imagine I have done an act which is outside AOA but within MOA, can the company ratify it? Yes. So any act which is ultra vires of AOA, which is a small document, but intra vires of company object clause, so shareholders can approve, validate and consent to it. Clear till here? That's it. Now we come to the next doctrine. So have you clear with these headings? What all you need to write? Now we come to the next doctrine called as doctrine of constructive notice. Sir, what do you mean by constructive notice? Constructive means what? Assumed. What does the word constructive means? Assumed or implied. Now let's understand what it is. The MOA and AOA of the company, they are public documents. They are public documents. On being registered, all these documents are available for anyone to inspect. And this ROC only ensures that on their website, MCA website, anyone wants, they can go and inspect it. This is given under section 399 of the Companies Act. Okay, that MOA are public documents. So if any person is investing into the company, associating themselves with the company, they are expected to know the contents of MOA. They are not only expected to know the contents, it is also implied. We are not only implying that they have the knowledge, we will also imply that they have the correct knowledge of the company. Clear? So it is a legal conception or a legal concept of presumption of knowledge. That if you're dealing with the company, you should already know what the object clause is. If you say that no, sorry, I did not read the MOA, will the company be bound to refund the money? No, because obviously you did not read. There was a, in our law, there was a concept called as caveat emptor. Let the buyer be aware. If you are buying the shares, you have some personal responsibility of reading the MOA, reading what the company is into. You can't go ahead and tell later, I did not read, give me my money back. So it protects the company from shareholders who are not reading the MOA, AOA. Constructive notice is implied knowledge of MOA, AOA, since it is always available for this. Okay. Now, then we come to the next doctrine, is your doctrine of indoor management. Now it starts from constructive notice and then we will go to indoor management. Clear till here? Let's understand what is indoor management. Indoor means what? As a shareholder, I will come to know anything that is public. So shareholders are expected to know what? MOA and AOA and nothing more. Nothing more. So only job that we will say responsibility, you should know MOA. Beyond that, you don't need to know anything. Okay. Now, the question is that if the company has not complied or followed anything which is internal policy, can the shareholder be held responsible? If the company has not followed the internal provisions, so why will the shareholder be responsible? Shareholder will say, I did the MOA, I read that is a maximum. I don't need to know anything more. I am not bound to know anything more. I would not have any opportunity of knowing what is happening indoors. So indoors, company will believe, the shareholders will believe that it is all going as per law. If there is any non-compliance, and I came to know that, listen, I know MOA, but I didn't know internally you did not do these all procedures were not followed. So I can ask for my money back, refund. Yes. So it protects whom? Protects shareholders from whom? From ignorant, non-compliant companies. Okay. Let's see. So indoor management, you will raise, it protects the outsiders against the company, because they would know MOA, they would not know what is happening indoors. This was held, also called, in which case law? Royal British Bank versus Turkwind. What is the case law we'll write here? Royal British Bank versus Turkwind. Okay. Now what was held here, that the directors had to take shareholders approval before issuing the bond. So imagine, they took the money from people and they issued the bonds, but they did not take the necessary approvals which was required indoors. So then the persons who had given the money, the bondholders, they said that, listen, we gave you the money, you all didn't follow the procedure, give us our money back, refund our bonds. You did not follow the procedures. So it was held that yes, the money should be refunded to the investors, because outsiders are bound to know the external position, but they would not have any idea about the indoor management. Okay. So The outsiders can assume that the company's internal affairs are being run in a valid way. Clear till here? Now there are exceptions to indoor management. When I say exceptions to indoor management means what? Normally, is the company bound to refund the money in indoor management? Yes, because logically they didn't do their job indoors properly, so then outsiders can claim their money back. Exceptions to doctrine of indoor management where the company is not held liable. So your company not held liable. If the outsiders had the knowledge of the irregularity, if the person says that I did not read the MOA, moment if someone has admitted that I didn't read MOA, so he will not be given relief also under the company law. If there was forgery, now imagine if there is forgery is some kind of a fraud, so we cannot validate fraudulent transactions. So we cannot make the company liable when the fraud has happened on the company only. Company itself is a victim. So in that case, company is not held liable. The person who did the fraud is liable. So in forgery, a company secretary had forged the signature. So will the company be held liable? Answer is no. The company secretary, that person who did the fraud, he will be held liable and not the company. Okay. Negligence was there. A person was bound to read and he did not read what was there. So he will be held liable. Okay. Then we see the other doctrine. The other doctrine is called as doctrine of alter ego. Alter ego is same like you're lifting the corporate wheel. In alter ego, just you have to write what do you mean by alter ego, and your very important case law is of Sunil Mittal. So you will see the case of Sunil Mittal versus CBI. So for alter ego, what we'll write? Sunil Mittal case versus CBI. In that alter ego means what? I, right? Whenever anyone say I am so big, I have done this, I have done that, very few people are like that. Okay, so that ego, okay, it's a Latin word which means I. So alter ego says that other I. Okay, so within the corporate embodies that the company and its shareholders are essentially reflections of each other. They are the two sides of the same coin. When I say other I means what? That other person and me are same. Other me. It's my shadow. It's the other me. Okay. So here what they are saying that if, now understand alter ego what it means. Company, if it does something non-compliance, they do a non-compliance or a wrongdoing. What do they do? Wrongdoing. You tell me, how will I arrest the company? Can I arrest a company? Can I put that on the pillar? I will go and kick it. Put that handcuffs on the door of the company. No, no. I need people to catch, drag, punch, kick. Right? So here they have said that normally, just like lifting the corporate wheel, for legitimate purpose, a company is different from its members. There is a difference between the company and the members. Company is an artificial person in the eyes of law. So company can act in its own name, appoint in its own name, sue in its own name, be sued in its own name. Some kind of wrongdoing, then the company will be held liable. But if we find that this wrongdoing is directly attributable to certain people, then we will say that you are the other I. Means you are that person who we will go. So company will lift the corporate wheel to see who are the wrongdoers behind and then punish the wrongdoers. So this was what they will say that normally in alter ego, you will overlook the formal status of shareholders and directors, and they will hold the persons accountable for fraudulent unjust transactions. Clear till here? Very simple. Which case law we will remember? Bharti Mittal, Sunil Bharti Mittal versus CBI. Okay, where they have said that in alter ego that it is the directing will and mind that should be liable. that who is the directing will and mind of the company? The directors of the company. They will be held liable in case of any wrongdoing. Clear till here? Then lifting the corporate wheel is same. We have done that also earlier, that lifting the corporate wheel is similar to what we have done. And when all the courts have lifted the corporate wheel, whenever there is a tax evasion. In tax evasion, we lift the corporate wheel to see who are the wrongdoers behind and punish them. Then if there is, let's say, to see that there is a alien enemy. If there is someone trying to doing a breach of contract. If there is any criminal activity. In all these cases, companies have lifted the corporate wheel to see who are the wrongdoers behind, and then they have been punished. Concept clear till here? All the doctrines? Okay. Here there are multiple cases. Dinchok Manaji Pate versus Dinchok Manaji Pate case and so on. Guilford versus Motors, then your Dalmor Rubber Tire Company. So there are multiple cases for this. You can take any one, two, and you can quote. Then when we come to this MCA 21, okay, let's see what it is. MCA 21, what is the other important things? See, in lifting the corporate wheel, which all the cases you can write? Your Dinchok Manaji Pate case where he tried to do tax evasion. Okay. So you can write this case law also. Dinchok Manaji Pate. He did tax evasion, so the law lifted the corporate wheel and found that he is responsible, and he hold them accountable. Now we come to the next thing is then Guilford case, Guilford versus Horn. Okay, so these are some of the lifting the corporate wheels, Rubber Tire Company, to find out if the company is run by an enemy, funded by enemy. Today we go to see some companies Indians are there, but they are funded by Chinese, so controlled by Chinese. So we can lift the corporate wheel sometimes to see if they have done something, who are the ultimate controllers of the company. Now my just one question before we get into the other parts also. Is company a citizen? Is company a citizen? Answer is no. Citizen is a person who has citizenship as per the Citizenship Act 1955. So citizen has to be a natural person. A natural person is only allowed to go and vote. Clear till here? So Citizenship Act 1955 states that you can go and only a natural person can go and vote. So even your state trading corporation versus CTO. Now, one very interesting thing is just two more questions from here for understanding that are the employee. Now I just want to understand from you these questions, okay? That can a employee of a government company be treated as government servant? My question. Very simple, that employee of a government company is not treated as a government servant, because government directly didn't appoint you, did not hire you. Government is acting as a shareholder, and shareholders has limited liability only till the amount of shares payment. No other liability can be there. That's one. Second, the government has come in as a trader or as an investor. Tomorrow when the price goes high, they can even sell. They are not hiring you as a government servant. So you are not directly appointed by the government. You are appointed by a company, and just a shareholder is a government. So you are not treated as a government servant. Second, now this is also interesting. Can normally writ petition is basically when fundamental rights are violated. Right? So only citizens can file a case for writ petition. Can a company file a writ petition? Can a company ask for writ petition? It was held yes. Now understand why. The law said that ultimately this company is owned by citizens. So if we affect their rights, if we affect the rights of the company, if we don't allow them to do business, so in return you're indirectly denying the rights to the citizen. So these are some of the case laws that you can write. Bennett Coleman versus Union of India, important. Okay, now let's look at the MCA portal, some of the parts. Ministry of, first let's see what is the MCA 21. They call it as, earlier, before the 20th, before this MCA 21 project, physical form filings were there. You had to fill the forms in ROC in physical forms, hard copies. In MCA portal, they made a digital revolution where e-governance was initiated and the all e-forms were introduced. Okay, and all CA, CS, CMA, all the agencies were allowed to do all the agencies were now allowed to file e-forms, and they had brought in other bodies. Some of these agencies are there, that's it. Okay, so this just one read you can do, that is sufficient for online filing, how you can do and so on. Okay, so we are done with this importance for chapter number 1. Now when we look at chapter number 2, very simple, very easy. From here, I personally feel that this will be asked in your examination. Small company, because of the recent amendment that is there. So what should be the paid up capital and what should be the turnover, 10 crores, and this will be 100 crores. That's it. So a small company is a company whose paid up capital is not exceeding 10 crores and turnover is not exceeding 100 crores. Clear till here? Rest we see the definitions. Let's see. Here you have this small company definition. What is the section? Section 2, subsection 85. Define the small company. A small company means a company other than a public company. So can a public company be a small company? We are talking of small company. So only a private company can be a small company which has paid up capital not exceeding 10 crores and turnover not exceeding 100 crores. Provided nothing of this clause shall apply to your section 8 company, holding subsidiary and any government by all this. So these are not small companies. Clear till here? Means a section 8 company cannot be treated as small company, your holding subsidiary company cannot be treated, and a company incorporated by this will not be treated as a small company. Clear? This is what it means. Now, here these are simple, so I'll not go into depth because we've always been studying just the section numbers. So what is a company? A company is any entity incorporated, formed, registered under Companies Act or any previous Companies Act. Section 2, subsection 20. Okay, so learning this will really help you. Now, company ideally has, let's say, 3 types of companies. If you read your section 3, subsection 1, it says there are 3 classes of company. One is a OPC, the other one is a private company, and the other one is a public company. Okay, now a OPC is given under section 2, subsection 62. Private company is given under section 2, subsection 68, and this is given under section 2, subsection 71. Okay, clear till here? Now for private company specifically, now see, when we come to private company, this is very important. This is generally students miss out on this, that if I ask you what is a private company, so a private company means a company which by its articles, we know that they cannot go to public, so they restrict the transfer. There is a prohibition on invitation to public. They cannot issue their shares to public. Transfer of shares can be done, but there is a restriction on transfer of shares. and the maximum number of members that can be there is how much? 200. Concept clear? So maximum 200 members. When we are counting this 200, past employees will not be included. Okay, so first we go to see your, in the note, joint holders will be treated as one. Common sense, if it is a one share, two people are owning, it is one member only. Now we see this in the counting of the 200. When we are counting 200, can I have 5 employees? Okay, let's see. Let's ask the question again. Maximum how many members can be there in a private company? 200. I want to add in more 5 members. They all are my employees. Can I do that? Answer is yes. Past and present employees will not be counted. So persons who are in employment and who have been formerly in employment will not be counted in the limit of 200. A very stupid, silly, you could say, situational question I will ask you. Let's say you were a member. Later, you were made the employee of the company. Will you be counted or no? You got my question? See, that was very simple. Past and present, I told you, are not counted. Future employee, will he be excluded or what? That means I first make you the member, shareholder, and after 1-2 years I make you the employee. Will you be counted in the 200 or no? You will be counted, because once counted, you will be counted. Because once you were counted, when you were issued to you, were you a past employee? Were you a present employee? No, only past and present are disallowed. Future you add anyone, they will be included because they were already included. Concept clear? So that is there.
So the member can be employee, but employee cannot be a member.
So yeah, you can say that. So this number does not include present and former employees. So it may be noted that exemption cannot be claimed by first being enrolled as a member and then inducted as a employee. Concept clear? Yes. Okay. Now, then we see so we did private company, public company, very simple. Holding. Subsidiary is also very simple. What is a subsidiary company? Yeah. Okay. Now, let's look at this thing. Subsidiary company. Now, if one company like Tata's is the holding company, right? So there is a holding company. Tata's is the holding company for Jaguar and Land Rover. Jaguar and Land Rover is the subsidiary. Now, how does this relationship become of holding subsidiary? So, holding company means a parent company. It must be holding at least how much? 51%. They control more than half of the voting power. So, they must be having more than 50% stake here. So, they become the holding company, controlling company. Or they control the BOD. Okay. Or they control the BOD. Or they would be a step down subsidiary. What would it be? Step down subsidiary. A step down subsidiary means what? A subsidiary is also my subsidiary. That means, let's say this is company A, this is company B, and company C is a subsidiary of company B. Company A is a holding for company B. Company B is a holding for company C. So can I say that this is also a subsidiary of company A? This is called as a step down subsidiary, because obviously you are controlling someone who is controlling me. So a company's a subsidiary's subsidiary is also my subsidiary. That's called as a step down subsidiary. Clear till here? Now, then we come to a concept called as associate company. Very important. You can mark it as important as well. Okay. associate company. Section 2, subsection 6. Now, let's understand the associate company. Let's say, if remember these thresholds, okay? Like, let me see if you know this. If you are below 14, you are called as a child, right? But moment you become 15 but less than 18, you are called as adolescent, and 18 you are called as adult. Can I say you are the same person but at different thresholds you are called something? At different thresholds I am called something. If I am not born, I will be called as unborn. So at the threshold where I am not even 1 year, I will be treated as a fetus. Okay. Unborn, okay. So now coming back, that different thresholds you are called something. Similarly, control. If a company is having more than 20% or more control, but less than majority, less than 50, we can say less than 50. So one company owns more than 20% stake but less than 50, so then that will be called as a associate, because it has a significant influence. It has a significant influence, but not that big influence to call it as a subsidiary. For subsidiary you require majority stake. If I have majority stake, here I have less than majority, so I am called as an associate. But if I have majority stake, it will be treated as a holding company. Okay, so then it will be treated that I am an associate of that other company if they are having control more than 20% stake. If I have in B, then B becomes my associate. Done. Okay, next. Then we come to dormant company. Dormant company, there will be an entire chapter on this, right? Which chapter is it? Chapter number 11. Okay, that is there. We will see dormant companies. Government company is very simple, where the government holds majority stake. Simple, whether it be central government, state government, or combination of both. Section 8 company is basically a NGO where the central government grants you a license if you have certain objects which are to promote certain arts, commerce, science, welfare, any other thing. License will be given. You don't have to put the word private or public around it. If you want to shut down, you require central government approval and NOC from tax authority. Common sense, because you are an NGO taking funds. Now you want to shut down, then central government approval will be taken again. Okay, and one interesting thing is, for section 8 company, proxy has to be a member. See, normally proxy need not be a member of the company, but section 8 company is like an NGO. Now imagine if a person with who is a profitable mind comes in the company, in the NGO, they say, what are you giving, distributing the money? So here we want in NGO, we want people of the like mind only. Imagine if someone who is money oriented. You all know anyone who is money oriented? Okay, so in that case, that person cannot be a part of a NGO. Okay, so I'm thinking of opening a NGO very soon. Okay, now coming back to lesson number 3. Till here it is clear, the important part. Now we come to a lesson number 3. Lesson 3 talks about MOA, AOA and its alteration. Now it's a very big chapter, but I'll tell you exactly what comes and how you can crack this chapter as well. Okay, all the important things I will tell you, and all that things you need to know. First, let's start with the what is a MOA, what is a AOA. Then we will alter it after knowing what it is. Okay, and then we'll see some important things that they can ask you in the exam. how do you alter one of the clause? That's a registered office clause. And then one concept about pre-incorporation contract. Let's see. First is very simple. Let's talk about MOA. Okay. What is a memorandum of association? I believe we must be having an idea. It's a foundation document. While incorporation, you have to submit your MOA. MOA will have certain clauses. Those clauses are mentioned in your section number 4. So when you look at your section number 4, subsection 1. So I'm looking at section 4, subsection 1. Subclause A, B, C, D, E, F. They'll have certain clauses. Okay, those clauses. So that's exactly what a MOA is. So MOA will contain, for example, the MOA is for insiders of the company or outsiders? It is for outsiders of the company. This MOA is mainly for the outsiders. You will notice that your parents have never ever asked you your name. What is your name? They don't ask you, right? Why? Because they already know it. So where do you stay? They don't ask you. Okay, unless they plan to disown you. Suddenly you come in the house after, they'll say, who are you? We don't know you. What is your name? Where do you stay? So very good chance if you are not studying, there is a possibility of some people who might be disowned. Okay. So now coming back, outsiders mean what? Outsiders would want to know your name. They would want to know how much, imagine you want to meet someone, let's say some boy or something. Wouldn't you want to ask you how much you are earning? First question. If he says I have taken a loan and I have to repay and I have a debt, I'm Vijay Mallya. What you will do? Direct U-turn and you'll run. Okay. So capital clause. Then comes, you can ask where do you stay. So you'll say, that Baju wali. Okay. So they will tell you that in the next door I stay. So the where do you stay is a registered office. What else question can come? What do your parents do? Subscribers. Who subscribed you? Who are your parents? Okay, subscribers. What other question you can ask? Liability, as I told you. So what liability you have? So he said there are 5 criminal cases going on. That's a liability, whether it is from company point of view, whether limited by shares, limited by guarantee, etc. And F, object, most important, we've written last. Object clause, from that we have a doctrine only, ultra vires. Okay, that's the most important. One more, F. After F what comes? G. Okay. So with immense respect, what do we say? You have respect. G. Okay. Now the thing is, this is for OPC. OPC have to give one extra clause comes which is only for OPC. Can you tell? Nomination clause. They have to appoint a nominee, that in 1% company, in case that 1% also dies, then who the company will go to, you have to nominate. For OPC companies, this will be there. All this is given in which section? Section 4, subsection 1, all the clauses. Concept clear? Then you have, with respect to name, they go on into subsection 2, 3, 4, that the name should not be identical to any other company, should not be against the government. Can I put Jahangir Tutorials India Limited? Cannot use the word India, Bharat, or anything which shows an association with the government. But we have Bharat Gas, we have Indian Oil. With central government approval, it is allowed. Clear till here? That is there. So this is the MOA, and the definition of MOA is given under section 2, subsection 56. Okay. So we can write this because it's almost sure and certain that they will ask you MOA, AOA, because there is a major chapter only. So MOA is given under section 2, subsection 56, read with section 4. And now we go to your articles. Now just understand, the MOA is there. If any of these clauses I want to change, okay, like tell me one thing, there was a company name Nippo Battery. What was the name? Nippo Battery, Nippo Limited. You think it's a very great name? They were subjected to bullying. Nippo, come here. So they applied for name change. What they applied? Name change. So this, is it necessary that you have the same name throughout? You have the same objects throughout? You have the same registered office throughout? No. You can always alter your MOA. That alteration of MOA is given in which section? 13. Till here it is clear. Section 13 is alteration of MOA. Now we are done for alteration. I will teach you how to alter it. Now we are going to articles of association. Articles of association contains the rules, regulations, bylaws. They are subordinate to the MOA. They are defined under section 2 subsection 5 and section 2 section 5. Understood? If for example there is any procedure given, I want to alter the procedure, then what is the provision? Section 14. Now let's see what is your sections. Okay, so for MOA and AOA, MOA is given under which section? 2 subsection 56. Read with not rule, it's section only. Section 4. Okay, rule is rule number 8 and 8A, which hits in your MOA for name. Then AOA is your section 2 subsection 5. There read with section 5. Now if you want to alter it, okay, these are the provisions. And now if I want to alter it, that is the amendment. Basically I call it alteration only. So alteration of MOA AOA. This by default you need to know, and in your especially even in your resolutions they will ask you that shifting of registered office. So just write to you that as per section 13 and 14. If I want to alter the MOA, then which section? 13. And if I want to alter the AOA, 14. Section 14. Clear till here? Very simple. Directly in the exam what they ask you is alteration. With respect to alteration, there is a particular technique to learn the alteration as well. Do you want to tell me, should I tell it to you now or later? Now. Okay. So for each one you can mark it as important. The summary has been given. It's a extremely important summary. Okay, and this I have prepared. You'll not find like this kind of beautiful summary anywhere. Okay. Yeah. So let's see. With this is the only provision that you have to comply. First, name clause. If I want to alter the name from Nippo, I want to keep it some other name. Okay. Then what do I have to do? Whenever you want to change the name, you would require a special resolution, and you also have to take central government approval. CG approval in which one? INC 4. This is the form number. INC 24 is the form number. Once central government has given you the approval and you have also taken majority consent of the shareholders, then a new certificate of incorporation will be given in INC 25. Concept clear? Yes. If there is this is name change, but if there is a rectification, now understand, this is a rectification and this is a proper name change. So if it is a name change, I have to take special resolution, central government approval, and INC 24 and 25 is done. In 24 I take approval of government, and 25 they give me the new certificate of incorporation with the new name. Clear? Now what is rectification? Rectification is, imagine I keep the name of my company New Horizon Limited. Isn't it a good name? New Horizon Limited. Later I came to know that there is another company which is in the name of New Horizon. I did not know earlier. They are registered, they have a trademark also, and they complain to central government also. They say, what you are complaining like a kid? I'll not change. Do what you want. So they go to the central government and get an order. Central government then directs me that your name has been inadvertently, unintentionally, we've granted it to you, but it is similar to someone else, so please go ahead and change it. So it is mandatory for me to go and change. I just have to take a ordinary resolution and I will change it. Clear till your rectification of name. Then this also is for listed companies, regulation 45 and 46. Let's see with respect to that what is there, that whenever you're changing the name, there are some things that you should have started the business with that. 1 year should have lapsed. Let's look at those points where they are given. See. Here. See, name change for listed companies. If a listed company is a big company, under regulation 45 of SEBI LODR, this is applicable to SEBI laws, listed companies. If listed company decide to change their name, then 1 year should have lapsed from the last name change. Can I change my name every single day? Today I'll give it Raju, then I'll say no, I'll give it Kaju, then I'll say no, yes. What nonsense is this? Every time we can't keep doing it, keep one name. So they tell you that one name has to be there for one single year. After 1 year, you are allowed to change. That's the first thing. Then they say that whatever new activity you are suggesting with the new name, at least 50% of the total revenue in the last year should have come from that activity. For example, I might be in the business of manufacturing and I must have entered into business of, let's say, trading. Now I want to stick into trading only, or maybe I've gone into software and I want to brand myself as software. So in that case, I would want to change my name into Software Limited. Okay, something related to software. So they are saying that okay, if you want to keep your name changed and you want to, then that activity which you are there, maybe show us that that activity is very dear to you, that activity is very important to you, that you want to change your name and add that activity in your name. So you know that Tata had launched this EV cars. The name only they kept Tata EV. So they are saying that if you want to change your name to reflect the activity, then at least generate 50% of your revenues from that activity. Then we will allow. Clear? Now, next is your investment required. The amount invested in the new activity should be at least 50% of the assets of the company. Means they are saying that if you want to change your new name pursuant to a new activity, then you must have invested also big amount, 50% at least in that activity. An auditor should have given you a certificate that everything is fine, and the details I will also put out on the website of the company. Is this perfectly clear? So these are some points which are important. Next comes your registered office change. This I will tell you, it's the most important and most repeatedly asked. From here also I'll tell you what they really ask is when you shift from one location to the other. This is the most important and this is the you could say the most frequently asked questions, FAQ. Okay, rest all is very simple. Let's see the other clauses first, then we'll come to this main clause. All the others require special resolution. So for object clause I want to change, I'll take a special resolution. Imagine I want to change the objects of the company. Company can change the object by taking special resolution. They have to give an exit opportunity to the shareholder. So any shareholder who is not agreeing, dissenting, we will pay them an exit. Capital clause, liability clause also I want to change. Special resolution I will take and I will close. Capital clause is alteration of share capital. We have a chapter. It is written that by ordinary resolution you can alter your share capital if you want to increase it. Okay, and SH7 is filed. Now when you see your registered office, if you want to change, how far do you go from your original place? For example, I was located in X place. See, people keep shifting their registered offices. It's very common. Okay. So if they go from one place to a very close by place, so it's not a big change. So you have to take a board resolution and this form is confirmed. INC 22. It's a form for shifting of registered office, which is the form number INC 22. local limits. Now I go a little beyond the local limits. Maybe my pin code has changed, but I am still within the same ROC, same state. Then I went a little far, so one compliance will add. I have to still take a board resolution, I'll take a special resolution, I'll take a INC 22, but only one new thing is added is what? Special resolution. Clear? Next, if I go outside the local limits where the jurisdiction of the ROC has changed, but it is still within the same state. For example, Pune has a separate ROC and Mumbai has a separate ROC. Both of them are in the same state. Which state? In Maharashtra, it is there. Both these cities are there. Two different ROCs. So what happens? Compliance will increase a little bit. So above all those things will be there. Board resolution, special resolution, INC 22. These were same as above. Now in INC 23, I have to take RD approval and a declaration from KMP that there is no default in the company's due and creditors NOC. This is rule number 28. Clear? Now this is the most important. If I am going from one state to another, now why this is the most important? Because this is the maximum compliance. All the others are less than this only. So let's say I want to shift my registered office from Maharashtra to Chennai or Tamil Nadu. I'm going to Tamil Nadu. So in that case, what I have to do? So all the earlier compliances I will do. I'll take a board resolution. I'll pass a special resolution. I will file INC 22. These are common. Then comes INC 23. I have to take CG approval. Then INC 26. I have to make a public notice. I have to inform everybody that the entire state I am shifting my registered office. Anyone has an issue, please come. Then when the central government gives me the consent, central government gave you the consent that okay fine, you can now shift your registered office. Then INC 28, once I get the approval from the government, I have to file it with ROC in INC 28. Again, the order copy received, the approval copy received from central government, I have to file it with ROC in form INC 28. So this is the and creditors NOC. Again, I'll repeat what it is there. So without seeing, now you all have to help me, okay? I told you which is the most frequently asked. You want to shift registered office from one state to another. Now this is the maximum biggest shift that you can do. What is the compliance required? The first thing I have to ask board of directors. Board resolution will be done. Do I have to ask shareholders? Shareholders obviously have to ask them. So shareholders approval will be taken by which resolution? Special resolution. Whenever special resolution is taken, one form is filed which is called as MGT 14. Do I have to take anyone else's consent? Central government? Yes. So I'll see first. I'll have to also file INC 22, which is the address, new address I have to give. Then I have to take central government approval. Which form? Next form only. INC 23 CG approval. This CG has given me the approval. Shouldn't I inform ROC? So INC 28 I will take inform ROC of CG approval. Clear? And then a public, I have to make a declaration. A public notice. Clear till here? Done. So this is done for shifting of creditors NOC and we are done. So we are done with this particular chapter as well. Okay. Now, so have you understood this? Now what is a pre-incorporation contract? Let me just clear it and finish it off. Very simple. Contracts. Now understand pre-incorporation contract also called as preliminary contracts. Let's understand from the name itself. You tell me what is a pre-incorporation contract. If imagine my incorporation happened here. My incorporation happened here on let's say this date today. Does the company get magically incorporated? No. Someone must be taking the steps to incorporate it, file the forms, appoint the directors, making the registered office, doing different things. That all must be there. So, in pre incorporation contracts, pre incorporation work is done by whom? What are they called?
Promoter.
Promoters of the company. Do you think that the lawyers would have charged for pre incorporation fees? MCA must have to file incorporation fees, stamp duty, etc. Who's paying that? Company is not yet formed. So that is the promoters who will do the pre-incorporation preliminary steps. In incorporation, I also have to tell them which is my registered office. MOA will contain, I have to file MOA. MOA will contain registered office. So I already have to speak to my landlord, pay him the charges, book my thing, and then have to inform. So someone has paid a lot of money that time. So all those contracts that they have entered before the incorporation, like for example, rents, or what do you call it, a lease agreement, lease deed. You must have entered into lease or rent agreements, employment agreements, contracts, various other contracts. Promoters must have entered. So once the company enters, once the company is formed, now all that contracts we will tell that it will be now in the name of the company. Earlier it was entered, the landlord will enter with the promoter. Called as in the pre-incorporation contract, he will say that I am, setting up a company. The company will be formed, and after it is there, a fresh contract will be entered by that company with you, and all these terms and conditions only. Now the question is, what if someone backs out, saying that the contract is between promoter and landlord? Promoter is entering on behalf of company. Now landlord will later have to enter into the contract with the company. But what if the landlord says, no, I don't want to enter? Or if the company says, no, I don't want to enter? Is it enforceable? Can they take them to court? Understood the point? I will say now that I had entered with promoter, a company were not there only. When I was there, how they can file a case? They were never a party to the contract. Because obviously company was not formed, so how company can file any case? So law, in English laws, these, it is not enforceable. These contracts, preliminary contracts, pre-incorporation contracts are not enforceable. But in Indian law, it is enforceable under section 16 and 18 of Specific Relief Act. Just write it down that preliminary contracts can be enforced by either of the parties as per the Specific Relief Act. Even though the company is not formed, it can still be bound, or it can bound anyone if they have agreed or entered into any contract with respect to the company with the promoters. Understood? So very simple, it makes sense because now today everyone will know that whatever I'm signing, company will have to do. Otherwise the other guy will have take me to court. That's called as preliminary contract. Now let's go to the next one. And 19, right? 15 and 19. So we'll make the well, Specific Relief Act. So we'll just make the changes. Your 15 and 19. Clear till here? Done. Now, if we see just one thing before we go into incorporation, whether it's come now. Okay, so we are done with this. Now we come to one topic which is very vast, but it is very simple. Extremely simple because it contains the basics. So it is your share, lesson 4, share and share capital. So we are done with lesson 1 to 3. Now doing lesson number 4. In lesson number 4, I have put out the important topics which are there. Types of share capital, what is a prospectus, what is a share certificate, security premium, private placement, all these things. Okay, so you can take a screenshot, or maybe I'll put out these notes on the WhatsApp group and also put it on the website. Now we go to see your important sections. Share. So what is the meaning of the term share? Section 2 subsection 84. A share is a share in the share capital of the company. Kinds of share capital. How many kinds of share capitals are there? How many kinds of share capital are there? There is only two kinds of share capital that is there. Shares are only of two kinds. Preference shares and equity shares. So preference shares are those shares that have a preference over the equity in two cases. One is at the time of payment of dividend and the other one is at the time of winding up of company. And in equity shares, till here it is clear. So equity shares are those shares which are not preference shares. Now in equity, there is one very important concept called as equity shares having equal voting rights. And the other one is, which is coming in your exam, which is your differential voting rights. It's given in your rule 4. DVRs, extremely important. Examiner's favorite question is what is DVR, what are the rules for DVR. We'll see. Nature of the shares are movable and transferable shares. Share certificates are always numbered. Okay, and share certificates are issued on which form number? SH1. If for example someone has lost the share certificates, okay, then it will be called as, then it will be issued and maintained in SH2. So new share certificates are given in SH1. Duplicate share certificates are maintained in SH2. Concept clear? Done. Then from share capital, this is one. Then we see your prospectus. Now in prospectus, when we go, there are few sections. First, the definition of prospectus you have to know. What is a prospectus? First of all, a prospectus is a document by which the company issues to raise funds from public. So a prospectus is a document issued to whom? To public. For what? For subscribing to the securities of company. Till here it is clear. The section you need to write. For example, today when we issue an IPO, you go and take the prospectus. In the prospectus, all the details will be given, and in that you have to fill and give it the application form to the company. In prospectus definition, they have given you two kinds of prospectus they have mentioned. Red herring prospectus and shell prospectus. Now, shell prospectus is given under section number 31 and red herring prospectus is given under which section? 32. Very, very good. Okay. So we are going to see here your prospectus is given under section 2 subsection 70. And they say that prospectus is basically of two kinds, two types they have discussed. One is shelf prospectus and the other one is called as RHP, red herring prospectus. Shelf prospectus is covered under section 31 and this is covered under section 32. Okay, so let's see. What is a shelf prospectus? In one line, if I have to tell you, a shelf prospectus is a prospectus for multiple issues. So let's take for example, every time I go to the public to raise funds, I have to file a prospectus with ROC, Registrar of Company. So he will look at the prospectus, he will suggest changes, he will tell you whether it is correct or no. But imagine if I as a company want to raise money in parts. I don't want all together now. I will take it for phase 1, phase 2, phase 3. So I will tell the ROC that listen, I am going to make multiple issues and raise so much capital. So every time I make an issue, I don't want to file a prospectus and wait for your approval. So I will file one prospectus called as a shelf prospectus. You can keep it on the shelf and I get a validity period. during that validity period I can make multiple issues. How much is the validity period? 1 year. So a shelf prospectus will have a validity period from the date of first issue for 1 year. So within 1 year I can make multiple issues, right? Second, every time I go to ROC, should I inform them or no that I went? ROC should know now how many times you went. So you have to file a document called as PAS. What is it? PAS2, called as Information Memorandum. Information Memorandum has to be filed informing ROC how many times you have gone to public. Approval I have to take only once in the shelf prospectus. That is it. It gives me a validity within 1 year. Then 1 year I can make multiple issues. Every time I go, I just have to inform them and go. I don't have to wait for approval every single time. Is the concept of shelf issue clear? Shelf prospectus clear? I'll just ask you one very simple basic question. Let's see whether you know it. Can a private company issue shelf prospectus? Obviously not. This is to go to public. Okay, so only public company can issue shelf prospectus. Now coming to red herring prospectus. Red herring prospectus is a prospectus which does not contain. So it is a does not contain price or quantum of issue. How much I am issuing, what is the price, I will not disclose. Okay, instead it will contain a price band. So imagine if I'm selling something, if I'm selling this phone, okay, don't you think I should tell you that the price I'm keeping it at 2 lakh rupees, right? So if you all want, you all can purchase it. This is directly giving one price for a security. But what if I don't know what to price it? I shouldn't overprice it, I should not underprice it. So then they issue a price band. They ask for bidding. That a bidding is taken, that you all tell at what price you all will buy, then on basis of the bidding I will set the price. So it is a process for price discovery. It is a process for price discovery where a bidding is done. A bidding is done, okay, in book building issue. Book building issue. It's called as book building issue, where the book can be seen that how many biddings I am getting. On basis of the market demand, I will price my security. I will see how many people are putting what bids. I will compare that I am not getting these many bids, so I'll keep the price accordingly. So what happens is it helps you price the security accurately. So the objective of a RHP is to price the securities as per market demand. Concept clear? Both are done. Then we go into this other things. Variation of, now this one part is variation in the terms of the prospectus. Now imagine if I have raise funds variation, section number 27. See, let's go to section 27. Variation of this. Now you tell me that the company, can they do anything outside the object clause? No. So I have raised the money from people telling the objects are this, telling these are the terms and conditions. Later I want to amend my object clause. I want to change my or vary my objects or my purpose, etc. So can I do that? With the consent, yes, we've read now that object clause also can be amended with special resolution. Without amending, you can't do. So if my company has mentioned that I am into teaching, can I start manufacturing business? I can start, but I have to first add it in the object clause and then do. So very simple, that if you want to vary anything for something that you've already issued and raised the money, so they take a special resolution, 75% consent. Dissenting shareholders. Dissenting means who are not agreeing. There are 25% who can be dissenting. You have to give exit opportunity. You have to give a what? repay, refund, exit opportunity you have to give to dissenting shareholders. Understood? And last, exit opportunity is given to dissenting shareholders. And last is I have to file a form with the government. What is that form number? See, check. It's a PAS 1 form. What form? PAS 1. So it's a form that I have made a public announcement, everything. Okay, clear till here? Yeah. Now, share certificates are issued under which section? In section 46, in that you go to see SH1 and SH2 is given. SH1 and SH2. SH1 is basically your share certificates, original share certificates, and this is about duplicate share certificates. And also remember that I'm teaching you all this, so you have to write sections in your so many times we tell, but when we correct papers, student has not written section number, form number. How do they expect us to give marks? Okay. Now very important, security premium. Security premium account is given in your section 52. Very important. And these are the important ones. DVRs. We will see when we are going through it. Okay. Section 43 read with rule 2. All these are the important topics. From here only you will see the chapter will be coming. Okay. Now let's go through it and complete it. So we'll take a bird's eye view and I'll tell you what all is important. We've already seen what is important, but while doing it also I'll give you the importance. First, the part 1 is the meaning and types of share capital. Here they just contain the basic concepts. Share, what is the meaning of the share, the nature of shares. Then what is a classification, what is a, I don't believe they can ask you and will ask you all these things, but in short, one is the maximum amount that the company can raise is called as what? Authorized capital or registered capital or your nominal capital. Let's say if that is 10 crores, 10 crores. Authorized capital. Is it necessary that the company will issue the entire amount? No. So it is possible that they might issue less. They are just planning to issue 5 crores. Just because they issued shares, issued capital is basically they have issued 5 crores. Is it necessary everybody will subscribe? If you are issuing 5 crores of shares, no, not necessarily everyone will buy. So then comes a subscribed capital. Subscribed capital, let's say, is 3 crores. Only 3 crore people have subscribed. And they've subscribed. Now the company will go and call the money. So called up capital. I will tell them, please, 3 crores. Either I can call up the entire amount, or let's say I'm just calling up right now 2 crore rupees. Later 1 crore I'll call up later. So if you call for money, you think everyone is going to pay up? No. Then you will have the paid up capital. Let's say paid up capital is 1 crore is where people have paid up. Most of the time you will see company law, they're using the word paid up capital, because that really shows how much you have in the bank account. That much has been completely paid up, okay, by the shareholders. We saw equity. How many types of share capital are there? Equity and preference. Now with respect to preference shares, and one important thing that preference shares also are issued. They can be issued for a maximum how much time period? 20 years, and for 30 years if it is infrastructure company as per section 55. Now tell me one thing, for equity shareholders, is it mandatory that I have to give them dividend? No, not mandatory that I have to give them dividend. Now there was secretarial standards, like how you have for chartered accountants, you have accounting standards, auditing standards. Similarly, for company secretaries also, ICSI has issued some secretarial standards. You all know what is SS1? Board meetings, how to conduct board meetings, entire ICSI is given you. SS2 is for what? How to conduct a general meeting, that has been given. So with respect to dividend, can you tell me which is the secretarial standards? What is the secretarial standard with respect to dividend? It is in line. It is in line. So what it would be there after 2? SS3. So always remember that in SS3 is also very important, and in your exam whenever you will write a topic about board of directors, shareholders, you write SS1, SS2. Now SS3 is about your dividend, okay, and it has been written in this that if at all the company could not pay. Now imagine if there is a default. I'm telling you one provision given in SS3, very important, that if the company could not pay the interest or any loan amount, they defaulted. Do you think the company should distribute dividend? No. So SS3 is saying that if the dividend is distribution of profits. Now imagine if you are already defaulting on loan amounts and employee payments, should you be allowed to distribute the funds? They will say, why you are giving away money? First pay off a liability. So in SS3 it has been stated that if company has ever defaulted, if there is a default which is subsisting, there is an existing default going on, then company should not declare dividend till that default is subsisting. First pay the dues, then give the dividend. Clear till here? Now imagine for preference shareholders, they get dividend. There are something called as participating preference shares where they can participate in X surplus profit. There are some preference shares where you give a fixed dividend. Now imagine if for 2 years consecutively we did not pay preference dividend amount, then they will come in the general meeting and vote on all the resolutions placed before the meeting. Understand? Imagine I'm a preference shareholder. I was expecting 12% dividend every year. 2 consecutive years they did not give me dividend. So wouldn't you be irritated? Wouldn't you want to go in the meeting and sit? The power has been given under section 47 that if the dividend on preference shares is unpaid for 2 years, then the shareholders have a right to vote on all the resolution placed before the meeting, and this their right will continue till all their dividends are paid. Clear till here? Then we come to your part B. Okay, so your chapter is divided into various parts. Your share and share capital is divided into various parts. Let's see. Issue and allotment of securities. First, of security. So what is the difference between share and security? Share is given under which section? 2 subsection 84 is the definition of share, and security is given under section 2 subsection 81. It is what? Security. What does securities mean? So securities is a wider term. It includes shares, debentures, preference shares, units of mutual funds, units of CIS, units of derivatives, multiple things which you know and you don't know. These are all financial instruments are called as securities. Clear? This is a wider term. Then we saw the term prospectus. What was the definition of the term prospectus? Section 2 subsection 70. Very important. Now 2 subsection 70, they had given you 2 examples of prospectus. Shelf and red herring. You know the section numbers 31 and 32. Red herring also we finished, and even shelf prospectus we have completed. Then share certificate. I told you share certificates are issued under which section? 46. Okay. Share certificates will be issued under the common seal of the company, sign of 2 directors, or if the director is unavailable, then the director and company secretary. Clear? Section number 46. Like I told you, SH1. In SH1, obviously sign off from some of the authorized person should come in the share certificate. It's of the company secretary. Now, if now section number 45, share certificate is a prima facie a document of title. If today you have a, let's say there was a person, let's for the example, there was a girl, she was driving in the wrong side of the lane. Everyone was coming from here, he was driving from this side. Okay, the police officer stopped her. She was very angry. So the police officer said, "What happened?" So he said, "All of them, they are driving wrong." Now you tell me that the officer, first question he will say that, "Do you have a license?" So she removes the license and she shows. Can the officer say that this license that you don't know driving? No. Because if a license is issued, it's a government document. It's a document on which it has already been told that she has this validity till so and so time. So you cannot state, because it's a prima facie evidence of driving. Similarly, if share certificate has been issued, it's a prima facie evidence. So on the first look, we will believe that you are the owner, and if it is said that it's fully paid, then that will also be a prima facie evidence that the payment has been made, and the company will be stopped from denying title or payment. Company will be stopped from denying that payment is not done, license is not issued, that they cannot do. Clear till here? That is it. So obviously I'm just giving the example of a girl, it could be a boy also. Next example we'll give of a boy also. Okay, so nothing like that. Okay, so next is SH1 is share certificates is original. It could be anyone who is driving in the wrong lane. Probability is also 50-50%. Next we see SH2 is your registered or the duplicate share certificates. Now let's go to the next important thing. So I told you prima facie evidence of title and even estoppel I told you. Now this is one small circular which was issued that is a share certificate and official publication. So the answer is no. First we'll understand that it is a prospectus, balance sheet, profit and loss account are official statements, official publications. But a share certificate is not considered to be a official publication, though it is a prima facie evidence of title. Clear till here? The problem is with the official publication. Official publication is for the world at large, like a prospectus, etc. That is just we have to understand. So I told you, company can they deny? Not the owner, payment not made? No. Okay. Then we see your next, your part C. So your part C talks about issue and allotment of securities. Here they will tell you how you have to issue preference shares, how to issue this share, that share, all different kinds of securities, how you issue. Now whenever you make an issue, let me tell you the base rule. Okay, the base rule in all this, that whenever you are making an issue, so let's say this is the investors and this is the company. This is the company. Okay, now the investor normally will give money. In return, the company will issue what? Securities. Securities wider means anything, preference, debentures, anything. Okay, now whenever they are issuing any security, this transaction has happened. Is the ROC informed anywhere? Registrar of company, government, have they been informed anywhere? No. So you have to inform or no? In which form will you inform whenever you make an issue? Very important form, mandatorily you need to know it. If you don't know it, you can maybe just tap yourself on the back. Okay, it is your pass 3. Pass 3. It is called as return of allotment. Return of allotment. So let's say if a company has made a public issue, of shares, will they have to file a PAS 3? Yes. If the company, a private company has issued shares privately, do they have to file PAS 3? Yes. If the company has issued anything, debentures, shares, PAS 3 is mandatory. So it's a common document which is filed. Under which section is PAS 3 filed? Under section 39. Clear till here? So if you go to see here, your section number 39. Okay. So let's see my memory whether. Where is it? See. You have your PAS 3. Okay. Not of the document, but PAS 3. See, whenever the company having makes an allotment of securities, it shall file a return in the prescribed form. And what is the form? PAS 3. Maybe somewhere we'll have to find. Here. Can you see here? Thank God it's there. Okay. Okay. So coming back to the next thing is your PAS 3. So this is done. PAS 3 has to be filed is done as per section 39. Nicely you can write it and close it. Now there is PAS 1 to PAS 5. Okay. Now whenever the company is issuing private placement, have you heard of private placement? 4 and 5. So then you have this 4 and 5 will be issued also. Private placement is different from public issue. Very simple. If the company is making a issue to public, PAS 3 will be filed. But when a company is issuing to a private set of individuals and not to public, that is called as a private placement. For private placement, you have on every single thing, it's a common form, PAS 3. But 4 and 5 will also be filed, right? 4 is for what? Offer document for private placement. Means when I issue it to an investor privately, not anyone else, so then I will issue it in PAS 4. And the record, I'll have to maintain a register in which form? PAS 5, register of private placements. Is this clear? Now only have to do PAS 1 and 2. Have we done that? PAS 1 and 2. We did 3, 4, 5. We did PAS 1 when we were doing the variation in prospectus, right? So PAS 1, a public issue will be made. PAS 2 is for what? In case of shelf prospectus, you have to issue a information memorandum in case of shelf prospectus. Then third is your return of allotment. We did 4 is your offer document private placement. And the last one is a register for private placement. 5 forms we have done clearly. This is the only PAS 5. These forms are only there and you should know it. And then we'll see, we'll complete a few parts. When you read your section number 23, section 23 states that issue, public offer and private placement. Private placement, there is only one section in company law. Anyone knows? Very, very, very important. I'll directly come to that only, is that important. Section number, make a guess what it is. 42. Good eyesight. Okay. So basically you have your private placement. Okay. So section number 42 is there, and we saw pass 2, 3, 4, 5. Pass 3, 4 and 5. We did that, right? So what is a private placement? A private placement is an offer made to a selected group of persons where company knows in advance to who they are giving, and company does not offer this to public. Public offer is there, you can give it to public. Okay. For public offers, you have your section 23 to 41, and for private, it is only section 43. Okay. Then section 52. Now see, there is again a chain of sections that we can learn in together. One is your section 52, 53, 54, 55. Okay. First is section 52 is, can I issue shares at premium? What do you mean by issuing at premium? Issuing beyond the face value. So it is called as issue of shares at premium. Section 52. Can I issue a discount? Yes. So issue of shares at discount is not allowed. Okay. But the provision is given under section 53 that issuing shares at discount is not allowed. You can issue debentures at discount, because it's clearly written that shares cannot be issued at discount. There's one exception to it, which is given in the next section. Sweat equity. Sweat equity. Okay. Now sweat equity definition is given under which section? Can you check on Google and tell? By the time you check, I'll write it down. It's section 2 subsection 88. Okay. So basically, what is sweat equity? Is basically someone who has worked really hard, employees. So when we issue equity shares to employees for their consideration of providing us some intellectual property, technical know-how, some trademark, copyright, patents, against that we are giving them equity share, that is called as sweat equity. So let me explain. That is under section 2 subsection 88. So let's see. Very important. If a person is here and a company is here, normally if a company is issuing shares, so here the company is issuing equity shares to whom? To their employees. Normally, if the company is issuing shares to anyone, in return, what do they take? Money. Consideration in the form of cash. Here we don't take cash. We take consideration in the form of other than cash. Maybe some intellectual property and rights, some know-how, some software that he has built. We'll take that in return. So this process is called as sweat equity. So what is sweat equity? Sweat equity is where the company issues sweat equity to its employees for consideration other than cash, for providing some intellectual property rights or technical know-how or value addition by whatever name called. Okay, this is given under which section? 2 subsection 88. Okay, I will just see some provisions. So is this clear? Issuing shares at premium, and that premium amount will go in a separate account called as security premium account. Company wants to, let's say, have a Halloween party. Can they use a security premium account? No. Security premium account is very clearly mentioned where it can be used. Issuing bonus shares, exactly there only the money can be used. Very important, you should know that, right? So you come to your securities, from here only. Which section? So your section 52 subsection 2. See, in subsection 2 only, and then in subsection 3 they forgotten some points, so they had given you that here also they can use this money. So it's basically subsection 2 and 3 is where all the money can be used. So money put in security premium account, can it be used for the director's daughter's marriage? No, it's not given here. What is given here? It is to issue bonus shares, to write off preliminary expenses, then to write off expenses which have been issued at discount, commission, redemption of preference shares or debentures, buyback, all those things have been given, fully paid bonus shares, and so on. Clear till here? So these are the only places where the security premium can be used, no other place. Which I have not read, we cannot issue it for that. If I did not read it, means it is not to be issued for security premium. Okay. And last is section number 55. It is for issue of preference shares. Almost all the securities when we issue, we require a special resolution only. Okay. By default, any kind of security we are issuing, which resolution we require? Special resolution. For 20 years we can issue it, not beyond that. If it is infrastructure company, then it is allowed for another 10 years, 30 years. Okay. Now we did sweat equity. Just for sweat equity, there is an important point. Let's see if we can cover it now. Sweat equity shares. Now market is important. Sweat equity shares. First is your section number, what it is there, which resolution I have to take. So this thing you can draw. Okay, it's completely unnecessary, but you can do it. If you're getting bored, then looking at this table feels good. Okay, so this is what for sweat equity. I had done like this when I was studying. So it is special resolution. These are all the sweat equity conditions that we are writing. Second, this special resolution will be valid for 12 months. Lock-in period, it will be for 3 years. So lock-in period is for 3 years. Means once I've issued it to the employee, can he sell it off next day? It's locked in for 3 years. Okay. Locked in for 3 years. Next we will see a company cannot issue more than 50% of the paid up equity capital or 5 crore rupees, whichever is higher, and total cannot exceed 25%. Market is important. Limit on sweat equity. Second, third, it's the limit. How much is the limit? 15%, 5 crores and 25%. What is it? 15%, 5 crores and 25%. So 15% or 25 crores, whichever is higher, right? Whichever is higher in a year. So if a company, now understand what it is. In my company, I am issuing shares to employees, okay, for providing know-how. Little bit I can issue. Imagine I want to issue 15% of my shares are sweat equity only. Doesn't make sense. So law said in a year 15% max. Then next year also I want to do 15%. Then next year also 15%. They say no. Overall cap is of 25%. In a year I can do max 15% or 5 crores, whichever is higher. That becomes my limit. Per year, my overall lifetime limit is how much? 25%. Very important limit you should know. And the register will be maintained in SH3. A proper valuer will be appointed to check that what is the valuation of that know-how that they are giving. You are giving him equity shares. In return, what are you getting? Let us value that intangible property also. So the form will be in SH3. The register will be maintained in SH3. Like this table I just made it just to make it visually good, that it's easy to remember also. Okay, right now it's not looking visually good. Okay, but you can write it well. Okay, then we come to your next part, which is your part D, which is called as alteration of share capital. Okay, very important part of the chapter. Okay, very important part of the chapter. Let's see your alteration of share capital. First, let me tell you, Section 61. Section 61 talks about alteration of. I'll put the all provisions here so this concept only gets over here. You want, you can write it down with me, okay? So section 61 is saying alteration of share capital. How we can alter the share capital? First of all, articles of association should authorize. We require ordinary resolution, and then I can alter the share capital. What do you mean by the word alter? It means to alter, means to change. Okay, it means to change. I want to make a changes. So what kind of change I can do? I can increase. Decrease is not covered because decrease is treated completely different in section 66. Rest everything is covered. If I want to increase the share capital, I'll go pass a ordinary resolution, AOA. If I want to consolidate, then D is subdivide the shares. E is cancel shares, not taken up by anyone. And C is basically converting my shares into stock and stock into shares. Okay, so this is alteration of share capital. That's it. If any company wants to do any of this, then they have to file a form called as SH7. This is as per section 64. Clear till here? So HH7 needs to be filed, okay, under section 64, where the company will say I want to increase my share capital, etc. Now what did I tell you in this entire thing? What will not be covered? Decrease. Because decrease, see here what is happening, it's a normal routine thing, or you're increasing your capital, so it's good. But imagine the company downsizing. Whenever a company downsizes, we need more scrutiny. It requires more questioning that why you want, what problem you have. Okay, so that is called as reduction of share capital. What it is called? Reduction of share capital. Now pay attention to this. Okay, reduction of share capital can be of two categories. One is one which requires approval of court, that is NCLT, and the second one does not require approval of court. Yaad tak clear? Now very important, when it requires approval of court, when I say court means what, there is only one company court which is called as NCLT. So at that time it is called, when you don't require approval of court, it is called as diminution of share capital. So when we reduce the share capital and it does not require approval of court, it is called a diminution of share capital. But if I am reducing the share capital, and it requires approval of court, then it is called as reduction of share capital under section 66. Clear till here? So normally when we refer to the term reduction, it always means section 66. So when we talk about reduction of share capital, it means section 66. Okay, because it requires approval of court. Other than that, it is called as diminution of share capital. We'll understand what it is. Very simple. Now we are coming to your section reduction of share capital. It's given under which section? 66. Now for reduction of share capital, what is happening? Company has their paid up capital. So it is a reduction of issued, subscribed and paid up capital of the company. What does reduction mean? They are reducing the paid up capital of the company. So for this, they are saying that what do you mean by reducing the capital of the company? That means the company is now giving away the money. It's become more risky. Imagine the creditors who had given the loan thinking that it's such a big company. Today that company funds are only gone away. So isn't it a risk to the creditors? Therefore they say that listen, if the company is now distributing its funds, so their capital is going to reduce. So therefore please ask your creditors, because company gave you the loan seeing your current net worth. Now reducing your net worth. So that is not fine. So here for this special articles have to approve. Special resolution has to be taken. Plus NCLT approval has to be taken. NCLT approval has to be taken. Okay, who will see whether you have taken the creditors approval or creditors consent is sought or no, or any other issue they have, then NCLT will deal with it. Clear till here? Now how I can reduce my capital? Imagine if I have money in my pocket, I can reduce modes of reduction. Modes of reduction of capital. How I can reduce my capital? If I have money in my pocket, I can repay. So you will pay back excess capital. Pay back excess capital. So for example, if people have paid me 10 rupees, I will give them 2 rupees back and I reduce my share capital. Other way is to extinguish the liability. What I can do? Extinguish liability. If someone has paid me 10, or someone has told that they have subscribed worth 10, I will tell them that listen, 2 rupees don't give me. That you have paid me till 8, that is fine, 2 rupees further you don't give me. So what did I do? I extinguished the liability. Before receiving only I told you don't give me. I'm waiving off your liability. That way also my capital will be reduced. And last is I cancel shares or cancel capital which are lost asset. What are they? Lost assets. For example, very simple. Think. The shareholders have paid up capital worth 10 crores. So I have received 10 crores in my bank account. With that 10 crores, I took a plant and machinery. With that 10 crores, what did I take? Plant and machinery. And there is a fire in the plant and machinery. A new worker came. He was trying to figure out how to start. It did not start. So then he said, let me just smoke and then see what happens. Smoked and there is a fire in the factory. Now that 10 crores is there or not there? The factory is burnt, assets are burnt, plant and machinery is burnt. So the asset is no longer there. So the asset is only not there, then asset side I have to remove it. So liability side also I have to remove something. I'll tell the share capital, sorry, the money that you gave is no longer available. I have to reduce it to reflect the real value of the company. That is called as reduction of share capital. So in this is there diminution of share capital, your diminution of share capital. What happens here? Diminution of share capital is there is no event, and these are very obvious things that are there, like buyback. It is considered diminished. Company share capital reduces, but it is very well known that you don't require NCLT approval. When someone has surrendered their share, or we have forfeited the shares. Forfeiture is also there. If we forfeited the shares, he could not pay, we surrendered. So in that the capital is reduced. Further, if the court has directed that whatever shares you have taken, refund it. So there I don't require NCLT approval because already it's on direction of court. So if there's a redemption of preference shares, so imagine redemption means repayment. So if I repay, my capital reduces. It's obviously fine and logical. In all these cases, you don't have to go and take the consent of the NCLT. Clear till here? That is done. So let's see. Any other important point left? Then that's it. Now we see transfer and transferability. In transfer of shares, very simple. I don't think too much of content is there in it, but simple. Transfer of shares. Okay. transfer of shares means you transfer the ownership. What is the difference between transfer and transmission? Transfer is during the lifetime. It is voluntary. Imagine if someone is dead, so his shares will go to his legal heirs. So did he transfer it? No. It is he's dead. It's involuntary. Okay. Second, in transfer, when I am transferring to someone, will you do it for charity or you want money in return? So there is consideration. Your ancestors, did they take money from you when you got the house or the shares or anything? No. Okay. So obviously there is no consideration involved. So if you go to see, transmission is when the shareholder died, it automatically goes to his child. Child didn't pay anything to get it. Okay. Then again, if there was no consideration, there was no documentation, there is no stamp duty. Here in transfer there will be stamp duty. In transfer there will be stamp duty because money is involved, no? So money is involved or a percentage of that amount. So stamp duty will be there in transfer. But here there is no stamp duty. Concept clear till here? Yes. Now one last thing, if you go to see, for transfer of shares, do I have to file any documentation? Answer is yes, you have to give the company that form, transfer deed. What it is called? Transfer deed. Transfer deed will be in which form? SH4. It will be in SH4. Concept clear? And this is given under which section? 56. Clear? Transfer deed means both the parties, buyer and seller, will give a proper transfer deed. It's like a sale deed. Sign and give it to the company, signed, stamped, and dated. Within 60 days of signing, they have to give it to the company. Clear till here? That is done. Nowadays, all this process is there or not there according to you? See, there is a concept called as dematerialization. In dematerialization, all their physical transfers has been completely stopped. Physical issue of shares has been stopped. Share certificate issue has been stopped. In India, only one type of company today is left that can issue physical share certificate. That is a small company. Under section 2, subsection 85. Only a small company is now allowed to issue shares in physical form, transfer in physical form. Rest all private companies, all public companies have to mandatorily issue shares in demat form. Demat means what? Open a bank trading account and from that you do buy sell. Appoint a nominee, it is done. This is called as demat. Now how do you open, like earlier what used to happen is, if I have physical shares, I will go to my whoever broker is there, okay, or bank. Normally the banks are also DPs, depository participants. I go to them and I file a form called as DRF form, dematerialization request form. It's a name of a form, DRF, dematerialization request form. I give it to my DP, depository participant. It could be my bank. This DP will go to the depository. Depository is the organization that holds shares in electronic form. There are only two DPs in India, NSDL and CDSL. Their main job is to convert physical holdings into online holdings. Right? So, do you directly, if you require any foreign currency or something, do you directly go to RBI? Do you interact with RBI? No. You interact with the intermediary. Same way, here we interact with DP, depository participants. And RBI here is depository. So depository is the ultimate organization that holds shares in electronic form, and the intermediary is your DP. Concept clear? That is it. Okay. Now here, so in this I've told you what all is important, what all can come in your examination. Everything I have covered in these topics. Only from there, I mean, can't say only, but you could say these are the most repeatedly asked exam questions. So very high probability that this will be it. Okay. Now we come to the next thing is your lesson number 5. Now luckily we've completed your big chapters. Now you have only small chapters which we can cover it smoothly. Okay. Now lesson number 5 is your members and shareholders. Let's see. Seeing your members and shareholders. So there is only one section that you need to know here. How many sections? One key section you need to know here is your section definition of member. See, definition of member is your section 2 subsection 55. That is the definition of member. If they ask you how modes of acquiring membership, that is also same. How you become a member, it is given in your section 2 subsection 55. How you can become a member of a company? Either I subscribe to memorandum of association, or I agree in writing. In writing, how I can agree? How I can agree in writing? For example, I file an application form for IPO, prospectus, or I have bought it, so transfer of shares, or I will say I am a nominee, so that is a transmission. And in writing, okay, in writing. And last one is I hold shares in demat form, depository. I become the holding shares in demat mode, the online mode. So demat mode, if I am holding shares in demat mode, I am called as a beneficial owner. For my benefit, all these shares are held in electronic form. Clear till here? Very simple. How to cease to be a member is I sell the shares, I transfer the shares, there is a death, there is an insolvency, and the shares will be transferred. Clear till here? This register of members that have to be maintained, it is given in your section number 88. Section number 88 talks about register of members. Okay. Now register of members is given in 3 forms. Let's see your section number 88 is your register of members. Okay. Register of members can be of 3 kinds: MGT1, MGT2 and MGT3. These are the form numbers. In MGT1 you are holding register of shareholders. So it's a register of shareholders. In MGT2 you are holding the register of other security holders. Register of other security holders. And in MGT3 I am holding foreign register. Okay, let's see. Here modes of membership etc. has been given. Now in this you can see who can become a member. So very simple. If you have a separate legal existence, you can buy the shares, but you don't have separate legal existence, you cannot become the member. So register of members, as I told you, will be in section number 88, and foreign register will be in your MGT3. Yeah. Mark this as important. Foreign register. Now, what is a foreign register? Foreign register is if a company has investors from out of India. Let's say I have certain investors from USA. So, if the company wants and is authorized by the articles, they can keep a register in a foreign country containing the shareholders of that country. Okay, that every entry made in the foreign register or duplicate register will be maintained here. So that if anyone wants to see here also in Germany how many shareholders are there, that also can be done. Entries will be transmitted to India within 15 days. It will be in MGT3. Okay. When you have set up also you have to inform ROC. When you have closed the foreign register also you have to inform ROC within 30 days. Okay. Now one important thing you can write it, section number 91 is about closing of these register of members. Now when we saw these register of members, closing of register of member, let me tell you what it is. Closing of register of members is given under section 91. You have to remember 30 days, 45 days and 7 days. Understand? Normally that the names of the shareholders, since it's online, people are continuously trading, buying, selling, buying, selling, buying, selling, they are doing. So if I want to give any corporate benefits, for example, if I want to give dividend, to whom do I give the dividend? If I go to give one investor, maybe he has just sold it. So company normally states that they will close the register of members. When they close the register of members, there is no transfers will happen that time. Whoever's name are mentioned, whichever shareholders' names are mentioned on that day, when they close the register of members, they will be entitled to the corporate benefits like dividend, etc. So let's say if I will tell that listen, transfers happen on the every single second. So I will say on Tuesday I'm closing the register of members. On Tuesday, whoever's names are mentioned, they will get the corporate benefits like dividend, bonus, etc. So that is how shareholders know, and that is how company also knows, and they will not be worried about continuous transfers. Now, for how long can I close the register of members? That is given in section number 91. I can close it for max 30 days at a time. At a time, I can close it for max 30 days. In a year, max I can close it for 45 days. And before closing, I have to make a public advertisement. Before closing this, I have to inform the public 7 days prior to closing. That is it. Then it comes that for how long I have to preserve the registers. Register of members have to be preserved permanently, and debentures and security registers have to be preserved for 8 years. Then there is a concept of beneficial owner. That is section, we did MGT 1, 2, 3. Now we'll see your section 89, okay, which talks about MGT next 4. MGT 4, MGT 5 and MGT 6. Okay, this talks about beneficial owner, this talks about registered owner, etc. Now let's understand the concept. That imagine if one person is a person whose name is registered in the register of member but does not have beneficial interest, means is the registered owner. He will inform the company in MGT 4. Beneficial owner will inform the company in MGT 5, and company will inform the ROC in MGT 6. Understand? If imagine I and my brother, okay, my brother is out of India, so he is saying that listen, what is it that I am going to be out of India and I have certain shares, I want to buy some shares, but I cannot come in this meetings, and I cannot come and do any act. So what I will do is I'll put the shares in your name, so I will become the registered owner, but I didn't pay the money. If me and my brother is there, my brother is out of India, he wants to buy shares. Now since he wants to buy the shares, he will have to come in the meeting, he will have to do some activity. So what he says that I don't want to put my name only there, I will put your name since you're in India. So I said okay, fine, I become the registered owner, but it is ultimately for the benefit of my brother because he paid it, he'll be the beneficial owner. So whenever this kind of transaction happens, The registered owner, me, I will inform the company that listen, my name is put in, but I have not paid the money. I don't own the thing. It is my brother who is there. Similarly, even the beneficial owner will inform the company that listen, I am the beneficial owner. I have just kept his name in the register of member to do procedural activities. So once a company gets a declaration from both the sides, then they will inform the ROC. So registered owner will inform in MGT 4, this one will inform in MGT 5, and this one will inform in MGT 6. Clear? So section number 88 also we did register of members. 89 we did beneficial and registered owner. Now we'll do section number 90. Very, very important. Section number 90, which is called as significant beneficial owner. SBO. And there are forms also of SBO. SBO 1, 2, 3, 4. Okay. Let's see who's a significant beneficial owner. SBO. Okay. Now I believe SBO can come in your examinations. Okay. SBO is important. Now what is a SBO? Significant beneficial owner. That section 90, okay, introduce the concept of significant beneficial owner to identify natural persons who directly or indirectly controls the company. So the section is in section number 90. I'll explain, but let's read the provisions first. Section 90 subsection 1 states that a SBO means an individual who is acting alone or through others holds indirectly, holds what? Indirectly not less than 10% shares, voting rights, dividend, okay, in the company. So a significant beneficial owner means a person who is having 10% of shares or voting rights he is having in a company indirectly. How he's having? Not directly, indirectly. Let's see. Now normally, let's understand the concept. If I am here and I am owning 12% of the company, let's say 10% or more in the company, 10% or more in company ABC. I am not a SBO. This provision not for that if I am holding directly. Because company knows me already. Why I need to declare that I am a SBO? Understand na? If I am holding 10% or more shares in a company, I don't have to make any declaration. Company already knows that I hold it. Here we are talking of indirect holding. What is indirect holding? Imagine if this guy is controlling. Now this is SBO is only for indirect holding. SBO is for indirectly holding 10%. Indirectly holding 10%. Okay, 10%. How? So let's say this person is having 100% or is having majority control. He is having control in company XYZ. He is having control in company XYZ. And this company owns 20%. Can I say he is indirectly controlling company ABC? See, this guy is having control here, which is having control in this company of 20%. So here the company, they are saying that if any person is indirectly getting control of more than 10%, then they have to disclose. So now this guy will have to go and tell the ROC, listen, I am indirectly controlling company ABC. They say, what do you mean indirectly? So they are saying that I actually control a company which is ultimately controlling this. So then the discovery of that web of the chain gets clear. ROC government comes to know that behind this company, this guy is the one who's having the control. So that becomes important. So the forms for SBO I told you. So what is the threshold? 10%. Directly, though, there is no problem only. We know that this guy is there. Indirectly, whoever is holding, they have to come and disclose. So they will come when one forms were there. They have to come and disclose that I am a SBO. I indirectly control which all companies. Then once the SBO, that guy, beneficial owner, will go and inform the company. Then the company will go and inform the ROC in Ben 2. Ben 3 is a register to be maintained in the company that how many SBOs are there. And Ben 4 is if someone is not filing and telling that he is a controller of the company indirectly, then company can issue a notice to him that we feel that you are indirectly controlling, you tell us. So notice is there in thing. Clear till here? So that is it, okay, in this chapter. Yep. Now we come to the next chapter, which is the next chapter. Wait. So members we have done the important parts. Now we'll see section number 6. Your lesson 6, okay? Lesson 6 is your debentures. So we will just start your lesson 6 after taking a 5 to 10 minutes break. Okay. So 5 minutes break we will take and then we will start with the part 2. We'll take a 5-10 minutes break and we'll come back. Then we'll restart. Hi. So, am I audible and visible? We'll be now continuing with the entire part and complete this particular thing also. Okay. So, let's begin. Just let me know in the chat box if I'm audible, visible, so I know we can quickly start and complete. Just waiting for you all to confirm. Just write the word audible and visible so I know that I'm audible and visible. I'll quickly start. First of all, don't forget to like the video also, and thank you so much for being there till the very end. Okay, great. Thank you. Let's begin. So now we'll continue with the second part of the lecture, where we'll be covering all the important topics with respect to your other chapters, continuing from chapter number 6. Now let's start with chapter number 6. Chapter number 6 has actually two chapters that are clubbed into it. One is called as debentures and the other one is called as deposits. Okay. Both of them are debt capital. What are they? Debt capital. That means it is a loan that the company has taken. If the company has taken a loan, what will they have to pay? They will pay interest. In both these cases, the company will pay interest. Now the provisions. So your part A is of the chapter is your debentures, and part B of the chapter is your deposits. Now debentures are covered under your section number 71 of your Companies Act, and deposits is covered from section 73 to section 76A. Any question that comes in the exam with respect to debentures or deposits, you will quote the section. We will see the definition section also. Definition for debentures is given under section 2 subsection 30, and deposits. Can you check and tell me what is deposit section? Before you check, it is 2 subsection 31. Okay, the very next section. Now, first is debentures. What does it say? That a company will issue. So let's understand what do they do in debentures. Here there is the investor and here it is the company. The investor will give the money. In return, the company will issue an instrument called as debentures. In this debentures, it will be written that you will get interest at the rate 12% for maybe a span of 10 years. After that, there will be a redemption. What does redemption mean? Repayment of your principal amount, just like it happens in loan. So this is what a debenture is. Now, to protect the debenture holders, because you see that when the company is there, you think the company will go and raise debentures from one person or thousands of persons. When they go to public, the debentures, like how shareholders are so many, even let's say there could be thousands of debenture holders raising it from public. Okay, now to protect the interest of debenture holders, so to protect the interest of these debenture holders, the company company law has introduced multiple things. Can you tell me what all protection is provided to debenture holders? Protection provided to debenture holders. All of this. There's only one section. Section number 17. And read with which rule? Rule number 18. Probably. Let's see. Or 17. 18 only, no? Wait. Let's see. The rule number 18. So all the rules are given under rule number 18. So let's see what is there, because all these people are there. So so many debenture holders are there. To protect them, What do they do? First, the company law has introduced a concept of debenture trustees. Okay, trustees will be appointed. These trustees will look after and protect the interests of the debenture holders. These trustees are appointed through a proper document called as a trust deed. Debenture trust deed. The debenture trust deed will be in which form? SH. Just check. It will be in which form? 12. I've already written it. It is SH12. Okay. Next, if you go to see your further to protect the debenture holders, law says that when we have to repay them, redeem them, we should also have some fund, special dedicated fund, so that from that fund we can repay them. That fund is called as debenture redemption reserve. Clear till here? So these are the protection offered to debenture holders. All we will see under section number 71, read with which rule? Rule 18. Concept clear? That is your debenture provisions. Very small, easy, and the concept gets done. All the rules, the duties of the trustees, etc. will be given. Now we'll come to the next part of the chapter, which is your deposits. Clear till here? So is section 17 is section 71 read with rule number 18 clear? I have told you all the key provisions that are there and the protection offered by the Companies Act to these debenture holders. Similarly, deposits are also given. Similar lines, deposit holders are also protected. Now let's understand what are their provisions. So section 73 to section 76A talks about the provisions of deposits. And I told you the deposits, which section we can write? No, I'm talking of this two definition, two subsection 31. Very simple. It is a definition of deposits. Deposits. Okay. Now, in deposits, there are rules given. Okay. Rules. In rule 2(1)(c), they tell you what are deposits and what are not deposits. What are not deposits? It is covered where? In which rule? Rule 2(1)(c). So they give you a list that the grants from the government and something. So those are important. So you need to study this. Very important. Okay. So here you will see when we start the chapter, 2(1)(c) will be given to you. Okay. And definition is section 231, which says any receipt by the company is called as a deposit. Company receives any money is called as a deposits. What are not deposits are given in rule number 2(1)(c). Now from 2(1)(c) also what is important, I'll tell you. The share application point is important. From directors, these points. So these are not deposits. Any of these headings which you see, these are not deposits. Amount received from employees is not a deposit. All this. That's it. Okay. So these are not deposits. And rule 2(1)(d). Can you check what it is written? What is 2(1)(d)? I've already written it. It is depositors. What is the rule for eligible company? It is very important. 2(1)(e). At least something is better than nothing. Okay, so 2(1)(e), very good. So if you can answer that 21E is for eligible company. You're very close to getting a exemption. Okay. Now, eligible company, what it is? So, eligible company is a public. Now, we'll see the definition. Then I'll tell you what are the key provisions for deposits. First, eligible company is a public company who has certain turnover. And one more thing, turnover and net worth, right? See, turnover and net worth. So if you see here, how much? 100 and 500. Turnover is how much? 500 crores or more, and turnover is 100 crores or more. So before I start explaining you the provisions, is this clear? That definition, that one is what are not deposits, 2 and C, who are depositors means anyone who's putting a deposit is a depositor. And eligible company means a public company which has turnover and net worth of 500 crores and 100 crores or more. So can I say eligible company here is a really big company? Yes. So now I will tell you what are the provisions for deposits. Pay attention. First, my question is deposits. That means taking the money from people, just like a FD. I take money from people, I take a deposit and then I give them interest. That's a FD, right? So companies can also do that. That is called as deposits here. What FD you do with the bank, you can also do with certain companies. That concept will be called as deposits. Now, my question is that should we allow all companies to go and raise deposits from public? Go and take as much money as you want from the public. Answer is no. They say, listen, if you want to take deposits from public, tomorrow when you can't repay, they all will tell that, see, all country, what is happening, government is not doing anything. So government says, as a protection, we will tell big companies only should be allowed to go and raise money from public. So from public, only which company can go? Eligible companies are the only companies who are allowed to raise deposits from public. The rule is given in rule 2(1)(e). E for eligible company. Okay. Now, from members and private people, privately and etc., who can raise? Private company can raise. Can a private company accept deposits? From their own members they can do now. They can't go to public. So yes, private company can do. Can a public company raise money from members? They can go to public also. So members, so they can go only. Okay, then government company, everyone can go, and members, everybody can go. Open to all. It's your own shareholders only. What do we care? When public interest is involved, we are allowing that only companies which have a certain turnover and certain net worth, only they can go and tap the public. Concept perfectly clear? Yes. Now the sections that are there are very simple. Section 73, 74, 75 and 76. And 76A is a punishment. Clear? Now let's see. Now I'll ask you a question first. Which company can go and take deposits from public? Where it is given? No, that is the definition of eligible company, rule 2(1)(e). Where it is written that a public company can go, an eligible company can go and raise deposits from public, that is given in section number 76. So eligible company can go and raise deposits from public. It's given in section number 76. Okay. Which resolution they will pass? Or which resolution? Or special resolution? So it is trick. Okay. So it is special resolution. That is all that has been written and it is done. Now, when you go to the public, can debentures be secured and unsecured? Yes. There are types of debentures. Similarly, even your deposits can be secured and unsecured. For example, from the public, when I'm taking the money, I can tell that if I cannot pay, you can sell this asset. So that is secured. So should I tell the shareholders that it is unsecured or no? If it is unsecured. So it is very important, because when it comes to public, government is like, be very careful. You have to tell whether it is secured or unsecured. Clear till here? Secured or unsecured has to be clearly informed to the shareholders in the document. Second, if a company is doing really good marketing, don't you think that they can raise a lot of money? Even if they don't have very good financials, still they will be able to succeed in raising money. But that is not good. So the government has also said that they get a credit rating from a recognized body. So at least tomorrow nobody says that why it has gone down. We will say rating was given that it is not very strong company. But you want to invest, so your risk. So credit rating also has to be taken. Clear till here? That is some key provisions. The other important section is your section number 73. Conditions under section, so this is conditions to issue deposits. Clear till here? Now this is the conditions to be followed when you are issuing it to members or when you are issuing it to public also. But for public, additional conditions have to be followed given in section number 76. Clear? Now we will see that in section number 73, various protection has been given to protect the debenture holders, which is same protection that was offered to debentures. Here, what was the protection given for debentures we had seen? First, we had appointed a trustee. Here also we will appoint a trustee called as deposit trustee. Then what was the other protection we had given for debenture holders? Debenture redemption reserve. Here also we will have a DRR, deposit repayment reserve. That will also be there. Then the trustees, how will you appoint them? With the help of a trust deed. Trust deed. Concept clear? And one last thing is, we will issue now, when we are not issuing it to public, we are issuing it to private person, then we can't issue prospectus. Prospectus is something which is issued to the public. So we will issue a circular called as circular inviting deposits of a document. When I tell that please subscribe, it is called as circular inviting deposits. Clear till here? Your provisions are done. Section 73 is very important, and section number, this is very important. 74 and 75 are not important, but I'll tell you what it is. 74 is so over, it is, you can cancel it only, because this was about existing deposits at the time of commencement of act. Commencement of act, when the act was commenced in 2013, so many years back. So this is now irrelevant. 75 is if I am accepting deposit with the intention to defraud. Deposits I have raised it with the intention to do a fraud on the people. Then who will be held responsible? Lifting the corporate wheel. The persons in charge, the directors, will be personally liable to repay the amount. Clear? So from seeing only you can tell which are the two important provisions, 73 and 76. Very, very important. Okay. And in this there are forms for deposits. That is your DPT forms. What are they called? DPT. Okay. So DPT. Okay. So what deposit? First one is the circular inviting deposits, is DPT one. The document that I circulate to everyone. Now DPT 4 is out of question because it was related to your section number 74 when the act was passed, and so this is irrelevant. Right now we are just concerned with DPT 1 to 3. DPT 3 is return of deposits. Now moment the month year ends, in the next 3 months this return has to be filed. So when does the financial year end? March. So then April, May, June. So by June, 30th June, okay, you have to file this return. That how many deposits are outstanding, how much money you have taken. Every year this filing has to be done. Understood? So a filing has to be done that every year how many deposits do you have pending, outstanding to pay. And DPT 2, okay, we'll see your DPT 2. It's a trust deed. Like when I'm appointing, so you can put this as deposit trust deed. Trust deed will be in which form? DPT 2. Clear till here? So when I'm appointing the trustees, I will appoint through a trust deed, right? So that is in DPT 2. Concept clear?
Yes.
So we are done with this chapter as well. So that is it. All this. Okay. Deposit trust deed. All this. So this is all that is there, that is important. In only one part I want you to study later is in 73 there is an exemption given to private companies. That, see how many, so many requirements are done to be done. This you have to do, that you have to do, but there is a exemption to private companies. Private companies don't have to do that. Concept is that only. Private companies are exempted to comply with those provisions given under section 73. Understood? That's all that you have to remember. Now we will go to the next chapter, which is your section number, your charges, lesson number 7. Now very simple, let's look at this, okay. First we will look at the concept of charge. See, understand that a company, you think companies could need a loan from banks?
Yes.
Obviously, money is needed, borrowed money is needed. So when the company goes to the bank to take a loan, let's say the bank will give the loan. In return, what will they ask? Collateral. Collateral is called as security. So let's say you have appointed this building that anything happens, if I can't repay, you sell this asset. Asset is kept as security. It will be said now that the bank has a charge over the property. Charge means a control over this property. So a charge is, in case of mortgages, banks have charge. So whenever any asset is kept as security, a charge is said to be created. Now when a charge is created, this transaction has happened, have we informed ROC? No. So they will give you specific forms where you have to go ahead and inform the ROC. Okay, we will see the forms. First, the definition is given under section 2, subsection 16 with respect to charge. A charge is any any interest, lien or any kind of security created on the assets of the property, whether it be in India, outside India, whether it be tangible property, intangible property, a charge is said to be created. Clear? Now what are the provisions of charge? Section number 77. Moment you create the charge, means I register, I take the bank loan and I put the asset on security, a charge is said to be created. You have to go and inform the, who have to go and inform? ROC. I'll go and inform. So these are the point that within how much time I have to go and inform also. So when a charge is created, you have to go and inform within to the ROC in CSG1. When a charge is created, means I have taken a bank loan and I have kept my property as security, company will sit and file CSG1 and they will file it with the ROC within a span of 30 days. If I could not file it within 30 days, then a extra time is given to me. Okay. So more 30 days time is given to me. Total how much? 60 days is there. And then later a further period of 60 days. So in total how many days? 120 days the charge has to get registered. So for example, I created the charge, within 30 days I have to go. If in 30 days I couldn't go, a further extension of 30 days is given. That is total of 60 days. If within 30 days also I cannot go, then more time has been given. But only difference is, as I delay, the penalty or the additional fees I have to keep giving. Clear till here? Now the other thing is creation of charge is done. Once I create a charge, so we saw that when there are three keywords, okay, three keywords: registration of charge, modification of charge, and the other one is called as satisfaction of charge. Now let's understand what it is. Registration of charge, that means moment I have created the charge, signed that documents, as per section 77 I have to go within 30 days, if not additional 30 days with paying additional fees, if not additional 60 days by paying the charges, I can go and register the charge. Clear till here? Next, if I make any changes in the original charge document, so any changes in the original charge documents, what could it mean? For example, I've changed the assets, or I've had a restructuring with the bank, I'm trying to reduce the EMI amount, I'm trying to increase the tenure. Any of those changes in the original charge documents, I have to inform it to the ROC as well. That is modification of charge. Clear? Satisfaction of charge is really satisfying, because it means that the amount has been repaid. So when you have repaid the entire loan amount, what will happen to the charge? It will be satisfied or released. So that also you have to inform the ROC. Within how much time you have to inform? So normal provision is always 30 days, but if I couldn't inform in 30 days, then 300 days time has been given. Every time I go later, I have to pay additional fees, and if I go beyond 300 days, then I have to go to CG. Beyond 300 days if I go, then I have to go to central government and I have to tell them, why didn't I give them the good news that the charge has been paid. Good news that the charge has been paid. Clear? Now if you go to see your form numbers, very simple. Is this clear? Satisfaction, modification and registration. Let's see the form numbers. I'll try to memorize the form number, is supremely simple. Now I'll give you the section numbers for this also. Your registration and modification of charge. Registration and modification of charge is given under section I'm going first, then I'll come to that. Section 77. Satisfaction of charge. Can you see in which section it is? I've written it. It is section 82. Okay, that is the section. Now let's see the form numbers. CHG 1. Now there is a sequence and a very simple way to learn this particular all the form numbers. CHG 1, 2, 3, 4, 5, 6, 7, 8, 9 and 10. Let's see. Okay. First is your registration of charge. Registration or modification of charge. I have to inform the ROC in which form? CHG 1. Now when I inform the ROC and the ROC says okay fine, the charge has been successfully registered, so which form he will issue? Certificate of registration of charge. He will say congratulations, you have now successfully registered the charge. Congratulations aap. Okay. Next, second, if when you have successfully modified and you have informed the CHG 1 about a modification, the ROC will say give a certificate of modification of charge. Now after this, let's say this much is there, it has been registered, you have modified, etc. Now comes with the respect of happy ending. What is a happy ending? Satisfaction of charge, that the loan has been successfully repaid. So you will make an application for satisfaction of charge. Okay, that congratulations, that I have paid the loan amount, I inform them. Then ROC will say that congratulations, the charge has been successfully registered. So it will be a certificate he will issue of satisfaction of charge. Clear? Is it necessary that when a loan is taken, it always has there's always a happy ending? There can be a bad ending also, that the person could not repay the charge. For that you will have to appoint a receiver. Appointment of receiver. Receiver means liquidator, to sell off the assets because the loan could not be repaid. Clear? Then comes your 007. 007 is for what? Something which is very secret, so you maintain the register of charges. Register of charges. Now remember one thing, that CHG 1 and CHG 9 are connected. CHG 9 is a registration for debentures, that when you are issuing secured debentures, so registration of charge for secured debentures. For example, debenture holders also, we have secured debentures, so assets have been secured to them. So when assets have been secured, so then it's a charge is created in favor of debenture holders. So then which form will be filed? CHG 9. If it is related to debentures, then CHG 9. If shares, then it is CHG 1. Clear? And then if you have filed it late, then comes condonation of delay. Condonation means pardoning of the delay. They will allow the delay. So delay by CG. And this is 10th one is delay permission by ROC. Clear till here? This is the forms. All forms clear. Now in section numbers also I told you 77, 70, 82. These are important. One more if I can say na, one more important if I have to say 78. Very interesting also. Section 77, that registration of charge by company. So the company should register the charge within how much time? 30 days, right? What if the company is not registering? Then who will get stressed? So there is one concept of consequences of non-registration of charge. From here only, there is, if the charge is not registered, it means consequences of non-registration of charge. Charge is not registered. Imagine a charge which was required to be registered is not registered. So what will happen? Imagine if I have taken a loan and I have secured a property and I have not informed the ROC. What will happen? ROC will say that why didn't you inform me that you have taken a loan, that this transaction has happened. So now you all will be treated as unsecured creditors. What you all will be treated? Unsecured creditors. And nobody can treat you as a secured creditor. It will be void against the liquidator and the creditors of the company, that they cannot come and ask that treat me as secured. Instead, if the same asset has been secured to another creditor and registered, he will get priority over you. So in front of you only, I will give a loan to someone else and I will register it, and he will become in over you, ahead of you. Clear? That is it. So consequences of non-registration of charge is important. So it affects whom? If who will become unsecured? creditor na, so the creditor is a bank will be like earlier I was a, if it was registered I would be secured, I would have protection. Now I don't have that. So then law had introduced another section which is section 78, registration of charge by the charge holder. Registration of charge by charge holder, that if he is no company is not registering, you go and register it, and whatever expenses are there you are allowed to recover it from the company. Clear? So these are the important sections. Okay, with this we are done with this particular chapter as well. Okay, and there's one concept called as crystallization of charge. Very simple. Let's see the concept. Okay, one is your there is a charge, could be of two kinds. One is fixed charge and the other one is floating charge. Fixed charge is on a specific asset and floating is on a class of assets and which are fluctuating in nature, like stock and trade. Like let's take an example. If I tell you that I am keeping this calculator as security, what is it? Fixed or floating? Fixed, because I've identified the asset and I've given that this property number is in your name. It's a fixed charge. Floating will be, I say that listen, I'm taking a loan and in my go down every time there is goods of 1 CR kept. So if at all there is any default, you can go and then sell any of those goods. So can I keep trading in those goods? Answer is yes, provided I maintain the minimum stock balance. Minimum balance of 1 CR. So new old goods will move out and new goods will come in. So the value will be intact. But it will be floating in nature because new stock will come in, old stock will move out. So you are secured. Okay, but in a floating manner. Now floating charge turns into fixed charge called as crystallization of charge. What is crystallization of charge? Is when floating charge is converted into fixed charge. This happens when there is a default. Imagine someone is a default, he has done. So then now imagine if the loan is defaulted. Then the charge holder, the bank will say, no, now whatever is there in the go down, please stop it. All those goods are mine. So now fixed floating became fixed. Now floating will not be allowed. Right? That is there. Now let's see the next part is your dividend chapter. Okay. Very simple chapter. Okay. Section 8, lesson number 8, dividend. Now first of all, dividend is given under which section? 2 subsection 35. Okay. And which is the secretarial standards for dividend? Okay, SS3. So confidently what we'll say? SS3. Okay, so we have SS3 is a secretarial standard for dividend. Very simple. What is dividend? They have told you dividend includes interim dividend. That means dividend could be of two kinds, final and interim. Final dividend is given at the AGM only. Interim dividend is given between two AGMs by the BOD. Right? Now, the provisions for dividend is given under section 123 to 127. 123 gives you the declaration of dividend. When a company declares dividend, it should be paid to the shareholders within how much time? 30 days. So if I declare the dividend, it will be paid to the shareholders within 30 days. But let's say if in the 30 days for some reason it was unclaimed or unpaid. It was unpaid or unclaimed for beyond 30 days. Then what we'll do? In the next 7 days, we'll put it into a separate account called as unpaid or unclaimed dividend account given below. Understood? imagine for 30 days, if the dividend is unpaid or unclaimed, then we will transfer that unpaid dividend into a separate account called as unpaid or unclaimed dividend account of dash company. In this account, money will be kept in, the unpaid dividend will be kept in for a span of how much time? 7 years. It will be kept for 7 years. After 7 years, we have to transfer it to a separate account or fund. That fund is called as Investor Education Protection Fund. It will be there in this account for as long as it is there. If an investor anytime wants to claim, can he claim from this fund? Yes, he has to file one form to claim this money which is unpaid, unclaimed from the account. What is that form number? IEPF 5. What is IEPF 5 for? Claiming the money. Investor, see, it's not that the money, if it is got in IPF, I can't claim. So, investor claim form is what? IPF 5. Clear? Now, IPF forms have been given to you. Okay. When there is unpaid or unclaimed dividend account, after how many years after, if it is unpaid or unclaimed, for a span of how many years, then we transfer to IPF?
7 years.
If it is 7 years unpaid or unclaimed, then we transfer it to IPF. When we transfer that amount, we'll inform the ROC within 30 days that this much amount we have transferred to IPF. Okay, IPF 1. IPF 2 is the statement of unclaimed or unpaid account at every AGM. In every AGM, they will be saying that how much amount has been unpaid or unclaimed. A proper statement will be made. That will be in IPF 2. That also has to be filed with the ROC. How much money has been unpaid or unclaimed. Okay, now imagine if a shareholder has not claimed for 7 consecutive years, he has not claimed any dividend. Imagine, not a single dividend he has claimed for a span of 7 years. Year 1 also he didn't claim, year 2 also he didn't claim, year 3 also, 7 years he was not there. Then we will say, we feel that he is only not there, we will transfer his shares also. So even the shares will be transferred to IPF within a span of, for 7 consecutive years. If your no dividend has been claimed, even one dividend during the entire 7 years, then it will be transferred to IPF including the shares. Means the shares will be freezed. Understood? So that is there. And now we look at the forms. When we saw all this, then 126 says that if there is a pending transfer means I am transferred it to you, but I have given the form, transferred it to the company, and the company is processing the transfer. So the company also takes time to process the transfer, no? From transferor to transferee. During that time, if the dividend is come, it will be kept in abeyance. Where it will be kept? Abeyance. Abeyance means in the side. After the process is completed, then we will give it. Abeyance means to keep it in the side. So obviously pending transfer is going on. So during that, if dividend is given, we'll keep it in the side. Okay. And if you act smart, what will happen? In 127, punishment will be given. The punishment also includes some defenses. What all defenses you can take, company can take, and that is it. Concept clear? With the concept of dividend. Section 3 also, SS 3 also clear. So 123 to 127 clear. IPF forms clear. Done. And last, if you see the 43A of SEBI LODR, that company should have a dividend distribution policy. That listed companies, top 1000 listed companies, need to have a proper dividend distribution policy, that at what profit level they will distribute dividend, when they will not distribute dividend, how much dividend is to be distributed, on what basis, what all factors they will see. So proper policy will be made. So there is more clarity to everyone, and there is a more uniformity in declaration of dividend rather than randomly declaring dividends without any basis. Clear? That is it. Now we come to the next chapter, which is your accounts and audit. Okay, section 9. Lesson number 9. Now lesson 9 is divided, your lesson 9 is divided in two parts. One is accounts and the other one is auditors. Now accounts is covered under your section 128 to section 138. Clear? 138 accounts. And auditors is covered from your section 139 to section 148. Clear? We'll see this and close, and very simple. Here the form numbers are AOC 1, 2, 3, 4 and 5. Here the form numbers are ADT 1, 2, 3, 4. Clear till here? From here, in auditors chapter, there is one specific provision which is applicable to company secretaries, which is ADT 3, which is about 143 subsection 12. Anyone knows what it is? No, sorry, ADT 4, which is about reporting of fraud. Reporting of fraud. That is very, very important that they ask in the exam sometimes. Okay. Let's see. Your first is section Board of Books or Accounts, section 2, subsection 13. You can nicely quote. Now, what is books of accounts? If you have ever done a balance sheet of financial statements, you will see that there is assets, liabilities. Before that, in your trading account, what all you have? Sales, purchases, data. And below that, in profit and loss account, what you will have? Your details of your profits and expenses and incomes. That is all what is there in your books of account. Clear? Then they have simply told, all this is not important, but just one read, that books of account will be as per double entry system. Okay, on accrual basis. Accrue means when they accrue, doesn't have to be on received basis. Accrual basis, like debentures are recorded, datas are recorded. Why? Because they have accrued. Receipt will be in future, but still be recorded. That will be there. It will be done as per the auditing standards. Okay, and the consolidated financial statements will be reported. What is consolidated financial statements? The holding and the subsidiaries reports will be given. 129 talks about financial statements, same lines what we have done here is the same, that financial statements will be as per the auditing standards. And it will give a true and fair view of the company's financial position. Then comes reopening of accounts. Very interesting provision, reopening of accounts. You know what is reopening of accounts? Imagine when there is fraud normally, okay, they reopen the accounts. When I say fraud means what? If there is a fraud or there is any non-compliance, that time they will redo the entire accounts. So let's see. What is reopening of accounts? They are saying that a company shall not reopen the accounts or recast its financial statement unless a application is made by the central government, income tax authority, SEBI or any other body, and an order is made by the tribunal to the effect that the accounts were prepared in a fraudulent manner or the company was mismanaged during the period. Now understand, if the government, income tax authority, SEBI, any other authority has made a complaint to NCLT and told that this account is completely fraudulent and it was completely mismanaged in the company and all these accounts that we have got is all fake, so what we will do? And NCLT is satisfied, yeah, there is a big scam going on. So then they will say that we will reopen the accounts, even in the past whatever you've done, we'll reopen the accounts and recast all the past entries to represent the true and financial picture. So that is called as reopening of accounts. So can I say reopening of accounts will be done in frauds only? When an authority has complained to NCLT, then only accounts will be reopened, otherwise there is no use in reopening of accounts. Now imagine no authority is telling me, but I myself have realized that I have done some mistake either in the financial statements or in the board report. So here the board of directors will write to the NCLT that listen, we have found out some casting financial mistakes. We want to revise it and make the corrections. So if they find that if the financial statements under section 129 or if the board report under section 134 are and there are errors, then board of directors will make an application to NCLT and NCLT will then say go ahead and make the revision correction. Simple. Then we come to one provision called as NAFRA, then National Financial Reporting Authority. Now this authority, it does not affect company secretaries at all. It just makes some people happy, which is we can call it as sadistic pleasure. Have you heard? If someone else is being tortured, so it gives you happiness. So some people could be like that. Do you know anyone who is like that? Okay. So here chartered accountants have been, under trouble due to this. Does it affect us? No. But somewhat you feel happy that NAFRA has been appointed as an authority to oversee chartered accountants. Disciplinary action is taken on chartered accountants by NAFRA. Okay, and whenever earlier the only chartered accountants used to ICAI used to come in and prepare their auditing and accounting standards by themselves. Now it has been said that you have to consult NAFRA. So can I conclude that because of all this new authority made above ICAI, okay, and above chartered accountants to oversee their performance, chartered accountants will have nafrat with CA? Yes, so that's one of the ongoing battles, if you see, that is always happens. So ICSI, do we have any authority like that on us? No. Company secretaries, do we have any authority above on us? No. But this gives us some kind of happiness that listen, someone else has failed but we have just passed. Okay, so this is NAFRA. They act like a authority over CAs and this, because they can take some action against them. Accounting standards you have to follow or not follow? Follow. One line, concept over. Then comes the next thing is your 134. Very, very important is your board report. Every year the board of directors have to prepare a report and send it to the shareholders stating the major developments of the what happened in the company. Now you will say, and it starts with the board of directors are pleased to tell you the following. And what all is contents of board report? Whatever chapters you have in your company law, just write it down. Whether company has declared dividend or no, whether issue of securities has been done, whether other point like which are whether loan has been taken or no, charges, okay, whether company has done some M&A. So those chapters, so you can write. In addition to that, director's responsibility statement, that we are taking responsibility that according to us all the things are correct. So that is there, and just signing a board report is important. Then comes one thing that we have to give our profits to charity. What is that called? CSR. Gives you happiness or no? That you are helping the society by removing your hard-earned money after paying tax. Okay, so that is called as CSR. CSR is basically nowadays it is believed that the companies have a responsibility towards society. So how much money has to be given is 2% of average 3 years net profit has to be distributed as CSR. This company has to make a CSR committee, and the CSR committee will look over the CSR expenditure, whether that money has been properly spent or not. Clear? That is the entire concept. Then it's simple. The members have a right to receive the financial statements, and then comes an important thing is your 137. The financial statements has to be filed with the ROC. Anyone knows which are the form numbers for filing? This is very important. Make a guess. It is on screen only. AOC 4 means whenever the company has concluded their AGM, they have to immediately report the approved financial statements has to be given to the ROC. That will be given in AOC 4. Clear? If they have subsidiaries, then they will give AOC 4 CFS, Consolidated Financial Statements. If it is under a company which is XBRL means certain thresholds if the company meets, then they have to file the accounts in a specific format which is internationally linked, called as XBRL format. XBRL is Extensive Business Reporting Language. That is so that international investors can also read. It's on an international level placing of financial statements. So very big companies, top companies report their financial statements in XBRL format. Clear? Then comes AOC 5 is the notice of the address where the books of accounts have been kept. AOC 5. Clear? With this we have finished the provisions of accounts. Now we'll go to the provisions of audit. Audit is very simple. Appointment of auditors. Appointment is imagine we have appointed. Now who can become a auditor, financial auditor? Only a chartered accountant. Clear? So our company, we found a chartered accountant, we appointed him as the auditor of the company. He became very happy, extremely happy, he was smiling. Very next day we used the second provision and removed him. That is called as section 140 is your removal of auditors. Clear? Removal of auditors. Now the thing is, imagine if there is bullying going on in the company. Okay, they are teasing him. Okay, and he feels that he doesn't want to work in the company. Then what he can do? Resign. So with this we have also completed our 3 forms. ADT 1, 2 and 3. Okay. ADT 1. ADT 1 is your appointment of auditors. Do I have to take consent of the auditors? Or I can appoint anyone I want? Consent of auditor is also needed, whether he wants to audit my company or not. Second is your once I appointed him, then what do I do in the next thing? Removal of auditor. Okay, the third one is if we harass the auditor, what he'll do? Resignation of auditor in ADT 3. Now imagine the auditor was there in the company and he starts looking into the books and slowly starts getting a shock. And he finds that there is a big scam going on in the company. And if they come to know that he came to know, they will kill him. Right? So what will he do? Imagine the auditor was sitting and viewing some of the books and he realized that there is a scam and all the directors are sitting outside with their bodyguards. Okay, so do you think he will come out and inform everyone that I found a fraud? No. So there is a manner on how you have to behave when you see a fraud. So reporting of fraud. So how will you report it? You have to, but what in the fraud you have to report in ADD 4. But you have to remember that if it is a small fraud, imagine a small amount of this is there, then you will just inform the ROC and the BOD and audit committee. You will inform. But if it is greater than 1 CR, then you will inform central government. Clear till here? There is a timeline that is very important that you have to follow, and your auditors, when I say reporting of fraud, is applicable to all the auditors. How many auditors do you know? CAs can be auditors, financial auditors. CS can also become secretarial auditor, and even cost accountants can be cost auditor. It's not only chartered accountants who are the financial auditors. There are other auditors also. Okay. So if you go to see your section 143 subsection 12. Clear? That is there, which talks about reporting of frauds. Which form? ADT 4. Very good. Okay. Now, eligibility to become an auditor is, you're talking of financial auditor, he has to be a chartered accountant. And qualification, actually they give you disqualifications. Very important that he should not be connected, he should not, they have given you thresholds, very important. Okay, do we have to pay him or he will do it for pay? Remuneration is important. 144 is important, auditor not to render certain service. Can you tell me that can the auditor give the accountancy services to the company? No. Because nobody bites the hand that feeds them. You can't check your own paper. Otherwise you will see that you will give your all India rank 1. When you give it to professionals to check it, then you get how much? 45. Okay, that will be there. After whatever liberation of 5 marks, grace marks. Okay, so whatever. Now if you see everything else is done, this is important, done. ADT forms also done. So chapter also done. Now we go to the next lesson number 10. Very, very simple, very, very easy. Is your compromise, arrangement and amalgamation. These are actually your provisions of section 230 to 240. Now I'll teach you a technique to remember all of them and then it is done. Okay, let's see if I can teach you that technique. So section 230 to 240, okay, talks about compromise, amalgamation, arrangement and amalgamation. Simple in mergers and takeovers. Mergers and takeovers. So let's see. First is section 230 to 232. Talks about the NCLT route for merger. NCLT route for M&A. Clear till your mergers and amalgamation. Means if two companies have decided to merge, like how you do a court marriage, then where you have to go to court. Similarly, if two companies they found each other and they feel that they have similar things and they can do business together for a long term. So what will they do? They will come together and amalgamate. In front of whom? NCLT. In front of NCLT. Okay. So NCLT is the process for this is a normal merger process. But can you tell me that isn't it a long going to court? It's ultimately a court, right? So then they said that we can have a 233 short form merger. What it is called? Fast track merger or short form merger. Fast track mergers. Two small companies are there. So let's say two small companies are there. They want to merge, so they can get merged quickly without NCLT approval. Or if there is a holding and wholly owned subsidiary, it doesn't affect public interest, so we will allow them fast track merger, quickly get merged. We have no problem, nobody has problem. Then startup companies, to start up companies, they are just started off, so they can also get merged. So now they don't require NCLT approval, someone's approval they require. Whose approval? Called as RD approval, regional directors approval. How much percent consent they have to take? 90% consent. Not only of them, even of the shareholders 90% consent, even of the creditors how much percent consent? 90%. If RD, if some objections have been received by ROC, RD and they don't want to approve it, then they will send you back to NCLT route. Not necessarily that they will approve, na? They can reject it, so then they will say go to normal merger process. That is a NCLT route. Clear? Now why only think about India? We can even think beyond India. So 234, section 234 talks about cross-border merger. Cross-border merger, where a Indian company is getting merged with a foreign company. So Indian company is getting merged with a foreign company. So inbound merger is when the foreign company is merged into the Indian company And outbound merger is when the Indian company is merged into the foreign company. So inbound and outbound is there. You have to follow the NCLT route only for your, but you require one additional approval of an authority. Which is an authority? Reserve Bank of India. Very good. Done. Then we see the fourth is your section 235 read with 236 and 238. 238. Okay. Where we are? 235, 236 and 238. They are all connected. They are talking about compulsory acquisition of dissenting shareholders. What do they talk about? Compulsory acquisition of dissenting shareholders. Means imagine there are some shareholders, they're like, no, we don't want to get merged. Now imagine there is a particular flow that if there is a acquirer company, and there is a target company. Okay, so this company is a big company. They want to acquire this small company, right? Now imagine after seeing the acquirer coming in, he is thrown in money. Imagine, would you want to sell your shares? Would you want to sell off your shares? No. But if someone is ready to give you 10 crores, you will sell not only the shares, but okay. So the thing is, you are ready to sell. If 10 crores is given, means good consideration is given. So in this, the target company shareholders, 90% or more have consented to the transfer. They have said, give us money, you take our shares, it is okay. But there could be some people who don't sell. So they are called as dissenting shareholders. Now they are very minority dissenting shareholders. So law has provided that you compulsory go and acquire their shares, because they are just so small and every time they'll keep fighting. And when 90% or more have given a consent, it seems like a bona fide offer. So therefore we don't want to stall the entire transaction. So we will say that if you see redevelopment in your building, nowadays all the buildings are going in redevelopment. Almost everyone will agree for redevelopment, but there might be 1-2 people who will not agree. Is there in your building also? There might be some people who will not agree. Rest everyone is there. I hope it is not you. Okay, who are that? No, everything happens. No, you want to do no, anything and you want no. So those kind of people, they just say no and object for the sake of objecting. They are litigious. They like to litigate. Okay, they are like people who are very vindictive and maybe a little crack also. Do you know any such person who's a bit crack? Okay. So if you go to see your 235, 236 and 238 done. Okay, which is about acquisition of shares of minority shareholders. Okay. Then we are done with, we are left with one more section. Which one? 237. So we are left with 237. Then which next one? 239 and 240, right? 240. 240 is punishments, right? Offenses and punishments. 239 is preservation. For how long you have to preserve the books of M&A. Let's say like your graduation degree, the M&A documents you can throw like this. When it is company has merged and they're like throwing. No, so you have to preserve it lifetime, or we could say till central government gives you approval. For CG approval required needed, or approval needed before disposing of the documents. Clear? And tell me one thing, now you all are at that age where you all might feel this, that your parents are somewhere forcing you to get married. So maybe just wait for 6 more months or clear your executive. You will see that your Indian parents, well, don't you think they force? Okay, so there could be Indian parents who force their children into getting married even when the children don't want.
Yes.
Why? Because what the society will say, what the people, family members will say. Similarly, central government can also merge companies in public interest. So if central government feels that two companies need to be merged for public interest, they will merge it. Clear? So there was a case of Air India and Indian Airlines. They had merged it. Even now, government wants to merge all the banks and into these things. So even if the banks are not okay, we don't care. Central government wants, they will merge, and then next they will tell you that whatever. That after marriage, in the next few months only, they will say that we want some entertainment in the house. Okay, so continues. Okay, so next is, so you're cleared with the section numbers 230 to 240. Then comes to the next one is majority rule. Majority rule is your after section 230, 230 to 240. Then comes your 241 to 246 or 5. It's operation mismanagement, class action suit, and force versus Harbottle. Very important. I'll just explain you what it is. That today, in the force versus Harbottle, in this case, two shareholders filed a case that the directors were mismanaging the company. Two shareholders filed a case in the company that the directors are mismanaging the company. Should the court take up the matter? Court rejected the matter. They said that why you all two are coming? The company can come by themselves. Company can sue and be sued. Company can sue their own directors. In this case, wrong is done on the company, so the company can come forward and file the case. So they said that and they laid down the rule of non-interference. Non-interference. That if the decision is taken by the majority, then the minority have to follow. Okay, minority have common sense. If in your building the majority have consented to redevelopment, even the minority have to follow. Similarly, if the company have decided something, even the minority will have to follow if the requisite majority is there. So that is the rule of force versus Harbottle, that majority rules is to be followed and minority shareholders who keep filing cases should not be entertained. Like if today any shareholder is coming, 2-3 shareholders, and go and file in Reliance, file a case in court on Reliance. Court will reject it, saying that listen, you all two are coming. What about the other shareholders? Let the collectively come together. Okay, so this rule was laid down so that there is no multiplicity of cases. So many cases would be there. Company would be able to function, smoothly, and it would be futile to entertain minority when the majority are agreeing on something else. Right? So that is there. That is the rule of majority. Now they said section 241 that if operation and mismanagement, that how many people have to consent for NCLT to take up the matter. Like some amount of threshold has been given that if that much threshold come forward, then NCLT will listen to the case. 1-2 people will come, they'll say get lost. But if a certain number of people as prescribed under section 241 will come and say that there is operation and mismanagement, then NCLT will look into the matter and remove the operation and mismanagement. How much percentage they have given you for operation mismanagement? See. Threshold means the required number is there, but to file this application, how many people are required? 1/10. See, how many people are required, members required to file? The quantum is given in 244. The quantum to file an application under 241. 241 is the application. Application should have minimum number of people as prescribed under 244. It says minimum of 100 members or 1/10, whichever is lower. So how much percentage? 10% normally. Clear till here? Mostly companies will have share capital. So they have kept 10% of the people should come forward and complain. Then NCLT will look and remove the thing. Similarly, class action suit is not only shareholders and debenture holders can collectively come and file a suit and remove the operation or mismanagement. Clear till here? With this we have completed the chapter. Now the last chapter we'll do it is called as dormant company. Okay.
244, that's a similar thing.
Yeah, 244 is a threshold.
Threshold.
Thresholds. Okay. Now we'll do your lesson 11. Lesson 11 talks about dormant company. Now dormant company is super simple. There is only one section that you need to know. That is section 455. And there are forms given which is MSc 1, 2, 3, 4 and 5. So first thing, what is a dormant company? A dormant company is an inactive company. An inactive company. Now inactive you cannot be for lifetime. You can be max inactive for how much? Maximum 5 years. Now question is, why will you be inactive? Now currently only we had a client. After 2 years of operation, he is starting, after 2 years of incorporation, now they are starting their incorporation. Now they are starting their operations. So for 2 years what were they doing? So the answer is, that was, they are dealing in supercomputers. Now for supercomputers they are importing machinery, setting up their manufacturing plant, etc. So what they have said that if a company due to business reasons they are inactive for some time, ROC will say, okay fine, you have a genuine reason, inform us. They will say that, listen, for XYZ reason, for holding a property, we bought a land, right now we'll make the manufacturing, and after that we will start our operations. So don't think that I am not going to start, and don't strike me off. Don't remove my name. Let me be there. They say, okay fine. If you are going to be inactive, please inform me. So MSc 1 is an application for getting the status of dormant company. You make an application. If NCLT is satisfied, they will grant the certificate. So a certificate of dormant company will be given by ROC. Then they will say, okay fine, now when you start the operation, then come and tell me. But they will say, come here. Till that time, you get active. When you get active, till that time, I want you to keep filing regular returns. Returns have to be filed. He said, okay fine, I'll file the returns, I'll maintain the number of directors, whatever is required, I'll do that. Then when you get active, inform. So when the company now wants to start the operations, then they'll give an application for active company, and the ROC will give you a certificate of active company status. Clear till here? That is there. Is the form numbers clear? Yes. Okay. So you have 455 and then you have all your form numbers also. Okay. Now when you see your secretarial standards, very important. Now we are done with those 11 chapters. Now just some important parts I'll tell you. First is your secretarial standards. You can't remember all, but at least top 3 you can remember. SS1 board meetings, general meetings and dividend. I want you to mandatorily quote in the exam. All these 3. You will definitely get an opportunity, because it's impossible. Question of dividend is not there, question of directors is not there, question of general meetings is not there. Quote it and come. Okay. Then I have given you certain threshold limits under company law. Different threshold limits. You can read it so that it's easy for you. Annual return, when it has to be filed, etc. Then in SEBI laws also some points are there which I want you to remember. Okay, some important things like independent women director, when it has to be appointed. So top 1000 listed companies have to appoint one independent woman director. How much maximum directorship one can hold? For example, I can become a director of how many companies? 1, 2, 3. So here they are telling you, for listed companies, a person shall not become a director of more than 7 listed companies. 7 listed companies. And if I am serving as a whole time director in one company, then I can serve as an independent director in not more than 3 listed companies. Understand? If I'm a whole time director, means I'm already dedicated to one company, full time. Then part time I can go for advising on some days is max 3 companies. This is also important. Risk management committee has to be made for all companies, top 1000 companies, right? That is some thresholds I've given you, that is important. And then comes the sums part. Now I've given you in this sheet, I want you to solve these sums. These are exam questions also. So don't miss the sums angle, because that also comes and then student lose 5 marks, etc. And these are very legal sums. Legal sum means if you know the law, the sums are very just simple addition and subtraction kind of things. So with this, I'll share this entire sheet with you all. Let me see. I think we are done with the entire. So with this, we have completed the entire marathon. For directors separately, I might give you something, or you can watch it from the videos, or we might have a part 2 for that as well. So this, I want you to go ahead, complete all your 11 chapters, and you will see all the key topics that I have given you. Questions come from there only, and more or less it covers a full chapter as well. So with this, I am done with the marathon. Thank you so much. Do like the video and share it with your friends as well. Take care. Bye. हो गया